use the mic.
Upon number 285 by 2016, I have paid for bail, my lord. He is in custody for more than 10 years, my lord.
WPC number 26004/2020. This is the second litigation matter filed by the petitioner matter. OA number is 101712 matter relates to engagement of substitute matter.
Engagement of
Substitute matter. So ready for hearing can be taken.
Mhm.
Another matter, my lord, 1319/2024. This is also second round litigation filed by the railway administration challenging the order of transfer. C.A.T. Court of Bench, my lord. OA number is 229 of 2011. Matter relates to fixation of pay matter.
Which item it is?
Item
Which item?
Only taken 2 weeks after Mr. Mishra is some personal difference. You
You'll
not
see that when the matter
fresh
is
matter.
Please wait.
Yes, yes, sir.
Pardon to bring a mention, Your Lordship, WPC 19620 of 2024. This matter was listed on 26th October, but since it could not reach, it has been delisted. It is a
page dokaji. Dokan.
Weekly list item number 1.
May item number 57. It is a just matter if my recollect is extensive had. May it be taken up in race admission item category. 57.
Item 54. Learning? So please make a mention when the other side are present. It would not be proper in the
At the time of reach, I will.
I will pardon you, Lordship. Item 13.
Please wait when the matter reaches.
Yes.
Make a mention or ask one of your friends.
Yes, sir.
To make a mention.
Yes.
Do not know what is there in the area.
This is a case matter, Your Lordship.
You see that?
Yes. Hello, bless.
Weekly list item number 1.
May I pray, my lord? Can it be taken up tomorrow? I have some misplacement of file. Item 1 tomorrow, my lord.
No, Mr. Also, I was going to your prayer. Please see that prayer.
My lord, my problem is I misplaced the file, so that's why I wanted.
If you want, it can be given to you in your pen drive. That's why. Just see that prayer.
One.
Item number 1 prayer. Why you want to go to from level 5 to level 4 and then again from level 4 to level 5?
Oh, that should be number 3. That's a typographical error.
I do not know.
That's a typographical.
Up,
That
again,
should be
down,
3.
so-
That should be 3.
Probably it's
4 to 3.
So just make an interim application to amend the prayer.
Yes, ma'am.
So that would you want it tomorrow or you want to make an
Day after
application?
tomorrow.
Day after tomorrow.
Yes.
Just file it
Yes,
here.
yes, ma'am.
It can be.
That's a little typographical error.
All right. So Jan Kumar also and senior advocate. 6 for an adjournment till day after tomorrow. Release this matter on 6th of November 2020. It will come in the supplement.
Yes, that's correct.
Item number 2.
Yes, my lord. Yeah.
Yes.
Well, there was direction to the government to file affidavit in this regard. Because this is regarding posting of a peon in the Justice of Baleswar. My lord, the selection list was kept valid till date. And thereafter, the my lord directed the government to take instruction and file an affidavit.
We've gone to our previous order. Mr. G.
My lord,
Have you gone through the previous order? That is 21/10/24.
Yes, my lord. Right. I had gone through that.
Please see that.
Since in the meantime, more than 11 years have passed, and it is the contention of the London Council for the petitioner that no recruitment to Group D post has been held in Justice of Baleswar after 21/7/2013. and the London Council for the State seeks some time to obtain instruction in that respect.
No, if you come to the previous paragraph,
My
last 4 lines, you will find that the petitioner's name finds place at serial number 22,
Yes, my lord.
and out of that, 15 persons have been given appointment in Group D post.
Yes, my lord.
And in the end of the merit list, that is most important, it is mentioned that such list shall remain valid till the advertisement of the vacancies for the next recruitment to Group D post in the just. So that was a list of 2013.
30,
We are in 24.
24.
In the meantime, 11 years
Yes,
have
sir.
passed. He made a submission that thereafter there is no recruitment to Group D post.
Yes.
That is the exact information which we want to obtain from the government council.
My lord.
So have you obtained?
No, it is not there. My lord, I will get that, my lord, in the next week, your lordship.
Can it be done in next week or
Next
a week
week,
after?
Yes, next week.
Next week.
Yes.
All right. Mr. Saroj Kumar Ji, and an additional government advocate, submits that as per the order dated 21/10/2024, he may be given some further time to obtain instruction, and the matter may be taken up next week. When counsel for the petitioner has no objection, there's this matter in the week commencing from 11th November 2020. Yes.
Item 3,
I'm praying for compassionate allowance under Rule 46 of the Pension Rule 92. But last occasion, I could not, my lord, produce the relevant rules for
No, your prayer is come to your prayer.
my
You please use that. He will assist you, Mr. Mahanti.
my lord, my lord.
He will assist you. Please see that prayer post.
Prayers.
Prayer, particularly number Roman 2.
To direct the opposite parties to consider the mercy petition for sanction of compassionate allowance in view of Rule 46 of the OCS Pension 92, considering his long period of service rendered approximately 15 years under the government establishment, taking into account his distress condition at the fag end of life, and keeping into the similar order of the government at 27/2/2020 regarding sanction of compassionate allowance. Well, so
When is that petition?
my lord, petition
This annexure 11.
annexure 11, my lord.
So this annexure 11 you have submitted in 2021.
Yes.
Do you mean to say that till date more than 3 years have passed, you have not got any response from the concerned authority, the secretary of the?
No, my lord.
We can direct this concerned authority to dispose of.
To take up this.
But here is a case, my lord. This petitioner who was dismissed from service.
Say time.
That is there.
Just write 2 lines if he is not entitled in view of such. Why are you keeping pending of that application since
Yes, ma'am.
2021?
No, it is my submission that since he has been dismissed from service, as per rules, my lord, he is not entitled.
No. It is only after a person is found dismissed,
Yes, ma'am.
this provision is applicable.
Yes.
It is in that contingency only.
He is
For
dismissed.
some allowance for that provision is there. So whether in view of that rule, whether he is entitled
He is
or
entitled.
not entitled.
Let him dispose of
So he
it.
has submitted. We are not expressing any opinion.
Yes, sir.
We just dispose of. If you have not disposed of, we are
Yes.
also right. The petitioner, Prabhakar Pani, who was the process server in the court of which court you are?
District Judge Baleshwar.
District Judge Baleshwar. Was dismissed from his service after inquiry by order dated 18/10/1985, right?
My lord.
He preferred an appeal before the District Judge Balasur.
Balas.
And what happened? That was dismissed. That was dismissed, which was dismissed by the order dated 14/7/1987. That is page number, paragraph number 7. It is the contention of the learned counsel for the petitioner that he initially submitted a representation on 8/7/2019. That is in paragraph number 9, right? What was your prayer in that representation? By annexure 7?
Right, annexure 7. It for same relief.
For compassionate allowance
as admissible.
as admissible under law, and that representation was not disposed of, for which the petitioner approached this court by filing a writ petition in WPC number 22653 of 2019, and court directed the authority concerned to consider the representation in accordance with law within a period of 2 months from the date of receipt of the order. The petitioner submitted a mercy petition before the authority on 6/11/2020, and again approached this court in WPC number 13918 of 2021, which was disposed of by this court with a
As we do.
direction
Dismissed as we do.
to the petitioner to approach the government for redressal of the grievance in accordance with law. That order is annexure 10.
Annexure 10.
And accordingly, the petitioner submitted a grievance petition that is styled as mercy petition. Mercy petition and prayer for compassionate allowance from the due date of retirement under Rule 46 of the OCS Pension Rules 1992, consequent upon dismissal of service after rendering 15 years of qualifying service. It said representation was made on 16/7/2021 to the Secretary, Department of Homes, Government of Odisha, Lok Sabha Bhavan, Bhubaneswar, District Khurda, with the opposite party number
1.
1. It is the contention of the land counsel for the petitioner that the concerned opposite party, he has not received, the petitioner has not received any communication from the concerned opposite party, and therefore appropriate direction be issued to the opposite party number 1 to consider the representation, the mercy petition of the petition by annexure 11 in accordance with law. Land counsel or an additional government advocate has submitted that he is not aware whether that representation has been disposed of or not. Considering the submission made by the land counsel for the respective parties without any expressing any opinion on the merits of annexure 11, if no order has yet been passed in disposing of the mercy petition by the annexure 1, the same shall be done within a period of 3 months from the date of production of the certified copy of the order, and The result thereof shall be communicated to the petitioner within period of 2 weeks from the taking of the decision. It is made clear that we have not expressed any objection. Yes, ma'am. Okay.
Item 4.
Another is to submit some instruction in this manner. It's not come regarding their entitlement. It was the order passed by your lordships on 22/10/2000.
We are passing it over. He's not there, maybe held up in some other.
Item number 5.
May I pray, my lord? The impugned here is the order dated 13/12/2023 passed with the collector Keonjhar.
Is it coming for the first time or earlier orders have been passed?
No, my lord, first time it's
First time. What is your prayer?
my lord, the prayer is that the rejection proposal of my lease is under challenge. That is at Annexure 21, page 142. May I straight take your lordship to the relevant.
You approach this court as it appears.
My lord, I have on several occasions and I have disclosed every time. And
what happened on the why have you approached and what orders were passed?
The orders that I have been relegated back to the collector to consider to dispose of my lease proposal.
No, when you come for the last time.
Yes, madam.
In what is the number of that writ petition?
My lord, that writ application is lordship may kindly write at 22055 of 2023, page 128. May I just place the case in not cell in one?
So it was dealt up by a single bench.
Yes, my lord. Because then the notice of the encroachment was under challenge, passed under OPLE Act. May I just place the matter, my lord, in one? Lordship, permit me 2 minutes.
I'll just we hear you. Just we want to see. So that your last application was disposed of
on 18/7/2023.
Liberty was granted to submit so-called reply in response to Annexure 3.
Yes, ma'am.
Which shall be filed within a fortnight from today. In the event any such reply is received from him, party number 7 shall consider and examine and pass necessary order as per law.
May I submit, well, in
What
fact,
happened?
that was not the last order. Last order is appearing at page 137. 21 November 2023. That is the last order.
The execution is disposed of.
I beg apology, my lord.
Collector and district magistrate Keonjhar consider and examine
3589, sir. Yes, my lord.
And thereafter providing opportunity of hearing to the petitioner, the representative shall appear to answer to pass necessary order. So that was disposed of. Then what happened? The authorities consider your case.
They rejected it, and I am before your lord.
Sorry, that is the rejection order you are
showing
to us.
Yes, my lord.
Annexure 21.
Yes, ma'am.
So what is your case? You applied for lease or what?
My lord, may I just
Yes.
In 2005, a memorandum of understanding was entered into between the government and the petitioner company for setting up an integrated steel plant. And as per the MOU, the government agreed in principle to provide 50 acres of land for the purpose of establishment of. Now, out of the then
in the district of Keonjhar.
In the district of Keonjhar. Epical was made the nodal agency. IDCO has been given the responsibility to acquire the land or provide the land. Now, my lord, your lordship can turn to page 66 at Annexure 4. Pursuant to this MOU, Annexure 4, page 66. Epical assess by an independent assessor, assess the requirement of land and comes to a conclusion that around 90 to 100 acres of land is required. And out of that, it has mentioned at paragraph 3 that 32.66 acre land I have already purchased for the purpose. So the balance 68 acre is required to be provided to the petitioner. Then, my lord, the IDCO wrote to the petitioner for submission of facilitation provisional charge of amounting to rupees 13,60,000 for the processing of the lease. That I have deposited. Then my lord, IDCO filed a formal application of lease before the Tahsildar, and that your lordship find out page 70. That lease proposal was then processed, and the lease was approved, my lord. That your lordship find out at Annexure 6, page 72. That's the lease case record. What happened, my lord? Initially, the proposal was for 49 odd acre land. And at the stage of objection hearing, it was found that one mining company, that is RP Sour Limited, is 11 acre out of that 49 acre was under his possession as a mining lessee. So that area has been excluded from the lease proposal. That you will also find out at the order at page 76. Right. Page 73 is the total 49 acre area with land schedule, and your lordship find out at page 75 at the bottom the general proclamation. May I place that? General proclamation inviting objections, if any, duly been published in the locality with a copy of Sarpanch so and so for filing of the objection has been over, and no objection has been received from any quarter. However, one petition was filed on behalf of RP Sao stating that some of the applied land of IDCO was coming under his mining leasehold area and has been granted the surface right over the said area. Peruse the order dated so and so Collector Keonjhar, where the surface right has been granted to RP Sao for an area of 62.70 decimal. It is found that the following government land applied for lease by IDCO Bhubaneswar is coming within the surface right area of RP Sao, and the said land are situated on the side of the are situated one on one side of the requisition area of IDCO, which were not recommended at present and set apartly presently. So this deduction has been made as per the land schedule at page 76. What is ultimately being recommended is at page 77, that is 37.39 acre. Where is that? That page 77. Peruse the field inquiry report of RI Joda, which reveals the land is free from encroachment and soil sources. There is no forest growth existing over the applied area. No natural irrigations water course will be obstructed by the proposed lease. There is no historical monument over the land. The applied land is situated over so and so. So accordingly, it is recommended, my lord. The last part is in view of, at page 79, in view of the above narrated fact and circumstances, the case record is submitted to the collector Keonjhar through sub-collector Champua for consideration of the sanction of the lease of land measuring 37.39 acre as per Schedule A in favor of IDCO Bhubaneswar for eventual transfer in favor of the Deepak Steel and Power for establishment of industry and payment of premium and ground rent, cess and other things. That's the land schedule, and it is calculated the premium. Now, since then it was pending with them, and the government on many occasions has, if a lordship, I can take your lordship through page 86. At this time, at the stage of consideration of lease, it was questioned that Sabik recording was jungle, whether it attracts jungle land or not. To that, the government has clarified that it is not attracted government jungle if it is not found place in the DLC report, district level committee, and it has never been found in the district level committee report. So accordingly, it was recommended and it was pending. I have established the steel plant over that by investing huge amount of money, and it was functional. So when this matter did not take forward and the lease proposal was not been allowed in my favor, I kept pending.
Lease was not given to, how did you establish the?
The possession, the adjacent land, they have chopped out this land for establishment. Now, out of that 32 I have acquired, 37 is their land. So the both amalgamated, and over that it has been established. So possession was with me, and it was a condition of the principle that within 9 months I must start my construction. that I am troubling your lordship at page 66, page 67. If the construction work is not started within 9 months from the physical possession, the land lease will be deemed to have been cancelled.
Okay.
So fact remains that I have established to the knowledge of all concerned, DIC gave me the PMT, government knows it, and already it is in implementation since 2009, and I am occupying the land pending this proposal. And at any moment the government says that whatever money and other things is to be paid towards premium, I am ready. I have never backed out. Now this proposal for some reason or other remain pending with the government. Now at that stage I approached this honorable court in 2011.
You said that the unit has been made functional.
Yes, my lord, it is functional, and the permanent registration certificate of the functional has been granted.
So before the proposal was given before the government,
Yes, my lord,
you were in possession of the property.
yes, my lord, it was
Under what capacity?
the capacity is the
Encroachment.
no.
Then?
Yes, my lord, that's what they are
That
now.
is what you must say.
My lord, that
That
MOU.
means you were in encroachment of the property and subsequently wanted that land to be in your favor.
My lord, the case is just reversed.
that is how
2005. My lord,
2BCC prosecution was against you.
my lord, I'm 2CC prosecution.
Yes.
I will come to that. My lord, in 2005 the MOU was granted. Then the process started to roll, and EDCO has been taken money from MOST for processing of the file. The lease proposal was filed, formal lease proposal. Lease was recommended in 2000.
Everything is correct. Your possession.
Yes, my lord. The EPICL and EDCO people have facilitated the possession, and that is how.
On what basis?
My lord, that's they have to explain, my lord.
You must have some
On the
paper
basis of
to
the MOU.
occupy the land.
On the basis of the MOU.
MOU does not give you the power or identifying the
that
land.
EPICL
It's a MOU on paper.
Yes, my lord. EPICL
Basing on which the subsequent process will be there.
Yes, my lord.
So where from you got the land? Basing on what?
Land has been given to me by the EPICL and EDCO.
What is that?
Well, that's EPICL and EDCO will say their condition is that I must initiate.
How could you know that this is that land?
Well, they have given it. They have given it.
Basing on what, sir? Some papers should be there.
My lord, that's exactly, my lord. That's why I made them party. It is for them to say before your lordship that on basis of what document they have given it.
No, you must have taken the position as you are saying. No?
Yes, my lord. I have.
Basing on what?
My lord, basing on their.
Somebody must have shown you.
Yes,
somebody
my lord,
must have identified you.
Yes, my lord.
Some kind of map should be there.
Yes,
Where
my
is
lord.
that?
My lord, map. All things are with the EPICL, and they have delivered the possession. That's what I'm saying, my lord. That is what my case, and they and everybody.
Such a huge amount.
Suggestion means it is orally it has been given.
My lord, physically they have demarcated the land and carved out, and then, my lord, for establishment of a steel plant, I just cannot do it without certain permission.
Even otherwise, such a huge land cannot be occupied without its identification. How can it be occupied, sir?
It was identified.
That is why encroachment case has been initiated.
Encroachment, that's the case, my lord. Encroachment case was initiated in 2023. And the government has also reported in the impugned order that the plant is over that. So had it been a case that I was encroaching from 2005 or 7, as the case may be, there was no encroachment, because everybody knows that a possession has been granted in favor of the petitioner company.
Who is that everybody?
Because these collectors, Tahsildar, and all the revenue authority, as well as the EDCL and EPICL people. So the case is rejected today on the ground that RP Sahoo's property has been involved in it, which is not a fact. Even the collector in rejecting doesn't say that I am in illegal occupation. What it says that the land which was given to the RP Sahoo has been granted, and so far as 2CC is concerned, both the 2CC has been passed by this.
And this RP Sahoo's objection is not correct.
RP Sahoo's objection is correct, and his land has been removed, excluded.
So where is the ground of rejection?
My lord, ground of rejection is at page 145.
Just show it.
On the other hand, may I just place, my lord, paragraph 3.
Yes.
On the other hand, it is seen that previously lease case number 15 of 2008 was booked by the Tahsildar Bodbil on the requisition of General Manager PEDCO to take the government land in respect of khata number so and so in village so and so, measuring an area 49.96 on lease to the industry project related to infrastructure with the view to hand over the same to the petitioners over the measuring 34 available in the name of the petitioner company. One RP Sao mines owner filed objection on the lease proposal of the IDCO, claiming that some applied land of IDCO coming under his mining leasehold area, he was granted the surface right over the same. Then, my lord, the land schedule of the RP Sao. The lease proposal for the balance land could not be materialized in view of the complaint of the RP Sao. Mine holder, that proposal of lease is coming under the surface right area hold, and some plots are found to be Sabik Kisam Jungle. So there are two grounds of rejection.
Yes.
One is that area is of RP Sao, the other one is Sabik Kisam Jungle. So, my lord, in so far as the first ground is concerned, that was never been recommended. This schedule of land at page 75, 76, if your lordship find out, has been chopped out, has been excluded.
Okay,
Categorically,
let us say that has been excluded. The balance land, if it is recorded as the Kisam Jungle
Yes, madam.
in the remarks column, then how without any further development or any permission from the
Yes, madam.
concerned authority, that would be given to you so that you will start a plant and
Madam, that's the case, madam. In 2008, the government, I am taking to your lordship page 86. This is when the lease proposal was saved. Clarification regarding applicability of Section 2 of Forest Conservation Act 1980 to the government land recorded in so and so. With reference to later dated so and so on the above subject, I am directed to say that clarification has been since been issued in the department so and so, addressed to all collector except the collector Anugul in respect of the plot of land which are not forest or do not feature in the affidavit of the apex filed before the apex court in connection with so and so cases. A copy of the said letter is enclosed for ready reference. Now, my lord, this land, they say, is not coming under the DLC land. And moreover, the government, in the lease proposal, it has been converted that this is not coming. If your lordship see the record of right I have annexed, record of right, if your lordship see at page 159, lordship may kindly see against those plot, miscase number 5, order dated, order passed.
Page 87.
Yes, my lord. In inviting reference to the subject cited, I am to say that the area and extent of so and so, there is a Sabik Kisam jungle to the remarks column of Arawa doesn't find place in the DLC district level committee report, on which basis the counter affidavit has been filed.
Read out.
In this context, the government in revenue and disasters management and later dated so and so has clarified that if the land do not feature in the counter affidavit filed before the Honorable Supreme Court, they may not attract the provisions of Forest Conservation Act, even if it carries the entry of Sabik Kisam Jungle in the remarks column of the record of right published after 1980. Therefore, you are requested to send the concerned case record for sanction of lease pertaining to so and so area where the Kisam is agriculture, and these plots do not find place in the DLC report as the MOU, as it is an MOU project. You are requested to take suitable action recommending the land. So that's
yes.
And Tahsil, they are also in the order observed the same. Page 75. So both the ground expressly doesn't exist and contrary to record. May I just place my lord page 75? As regard to the Sabik Kisam jungle, in the remarks column of the plot so and so, whether the land was attracted to the provisions of Forest Conservation Act, the matter was referred to the government in Revenue Management Department for clarification. I think that the land which are not forest Kisam land and do not feature in the affidavit of filed in connection with publication number, they may not be attracted Forest Conservation Act, even if they carry the entry of Sabik Kisam jungle in the remarks column there.
So, in this matter, what has been done? So notice has been issued, or you
No,
have
my lord.
caveat
So
your
here
No.
I have filed caveat for the opposite party number because I have entered into the land in question by virtue of a fresh lease deed executed in January 2021. I am the new lessee. And the lands which now the petitioner wants to be settled in his favor.
No, that he said that it has been already excluded. You are
No, that
for appearing for that Ramprasad's house.
no.
No, no.
Then
Now
No.
the lease granted in favor of R.P. Sahoo has expired in March 2020.
okay,
I am the new lessee since January 2021.
okay. You have not been made a party.
No.
Yes, my lord. They have made party.
My lord, may kindly see page 137.
Yeah.
Though in the last read proceeding I appeared and I raised my objection regarding maintainability, but I was not given notice by the Tahsildar. Anyhow, I am ready to assist my lord. My lord, the lands in question which the petitioner wants settlement in his favor, my lord, that has been granted in my favor by virtue of a fresh lease deed executed in the month of January 21. Now I am in possession of the entire leasehold area.
The entire land has been given in your favor.
Yes.
In that lease.
Yes, including the land in question which the petitioner wants allotment in his favor.
So that he has not mentioned in the
Impugned order. Absolutely nothing mentioned, and I didn't know. It's for the first time.
If that is so, then this annexure, the rejection order, that is that annexure 21, which is under challenge, nothing finds place that what you are appearing for whom you said?
For the OP number 11, Odisha Mining Corporation.
OP number 11. You just come to that ground. You have received a copy.
Yes,
na?
yes.
Just see the ground which is highlighting.
Yes, I have seen that.
Why it was rejected? It was only on two grounds. If you find page number 146,
Yes.
that the lease proposal for the balance land could not be materialized in view of the complaint from Ramesh Prasad Sao, mines owner, which he says that has already been carved out, that has already been excluded. And the second one is that some of the plots are coming under that Kisam jungle. That is
in fact,
this order was passed in 2023, and you said that you have been given the lease in 2021.
January 21.
It should have mentioned here.
Well, my case has been reflected at page 145. Sub-paragraph.
145.
May I place my lord? Sub-paragraph.
Yes.
Whereas Peru's memo number so-and-so dated 2/5/2023 of Additional Secretary to Government Steel and Mine Department, in which it has been reported that defunct plant and machinery of Deepak Steel and Power Limited have been set up unauthorizedly inside the mining lease area of Guwali Iron Ore Block of Messrs. OMC Limited of Bodbil Tahsil of this district, which is required to be demolished, removed as encroachment for facilitating smooth operation of the mines by the OMC Limited, and has also requested to evict the plant and machinery from the mining lease area of OMC Limited from the above schedule of government land.
Okay, so
These are the government lands,
Hmm.
and he is in unauthorized possession of that land. My lord, may kindly see. Well, in fact, in 2011, he filed a writ petition for grant of this land. My lord, may kindly see the writ petition and the order passed there.
I have annexed it.
No, you have not annexed the writ petition.
Which is that
Well, I am producing the copy of the writ petition.
I have annexed the counter affidavit and the order.
My lord, may kindly see the prayer made in that writ petition at page 9. Page 9, my lord, may kindly see. It is therefore humbly prayed that this honorable court may graciously be pleased to issue rule I say, calling upon the opposite parties to show cause as to why a writ in the nature of mandamus or any other appropriate writ shall not be issued.
just
Yeah. What? Yes.
This is filed by one Haricharan Gupta.
No, this is the
Yes,
no,
my
this
lord.
was filed by the
company.
petitioner company,
Achha.
managing director.
Managing director. Okay. What is the prayer made?
It is therefore humbly prayed that this honorable court may graciously be pleased to issue rule I say, calling upon the opposite parties to show cause as to why a writ in the nature of mandamus or any other appropriate writ shall not be issued directing the opposite parties to allot the land measuring an area of acres 37.390 decimals in Mauja Tupadi under Bodbil Tahsil in lease case number 15 of 2008, described in the land schedule under Annexure 3, excluding the land area described under Annexure 4, and further be pleased to direct the opposite party number 7 to provide allied facilities to the petitioner upon perusal of causes shown, if any, or any insufficient causes shown, make the schedule absolute and may pass appropriate order as just and proper. Now, what was the final order, my lord? May kindly say I have annexed at the top. In the affidavit filed by the opposite party number 4, it is stated that without waiting for permission from the Government of India under the Forest Conservation Act 1980, the petitioner has gone ahead and established a sponge iron plant over the forest land. It is further stated that the forest lands in Sabi Kisam have been converted by the petitioner into non-forest land after 1980 without complying with the Forest Conservation Act 1980. The petitioner appears to have even laid a water pipeline within Siddhamatha reserved forest of a length of 1,775 meters for drawing water illegally from Kara River for the sponge iron plant. Further, it is stated that a forest offence case has been registered against the petitioner as a result of the above violations. Despite the above affidavit having been filed on 7 December 2011, till date there is no rejoinder affidavit to contradict the above aberments. Consequently, the court is unable to accede to the prayer of the petitioner that a direction should be issued to the opposite party to grant the lease in respect of the land in question in favor of the petitioner on a formal basis, or to get IDCO to transfer the land in question in its favor. The writ petition accordingly. Well, this order has attained finally.
So the same, almost same prayer.
Same area is
Challenge this order in the higher forum.
My lord, no.
Then
My lord, may I just place it here? This based on the two things. A, that I didn't file any counter to the rejoinder to the counter. My lord,
not
may I just pay my may I just come? The two things noted down there, that there is a forest offence being initiated against the petitioner and the work has been done within the forest area. This is based on the wrong affidavit, or
whatever it may be. Once the order has been passed, it has reached finality. You have not challenged the order, and that lease cannot be granted. How you can file this petition again? That is self-same prayer.
No, my lord, the reason being the facts noted down there.
Whatever may be filed, you could have filed a review petition. You did not file. You are going on filing one after another writ petition. You have not challenged the order either before the Supreme Court or file a writ petition, a review petition. So that order that the lease cannot be granted to you in your favor, that has attended finality in the. So how can another division bench just take a contrary view?
May I just
If you are,
two things
have filed the review petition. No, in that case, if you have not filed the rejoinder affidavit, you have not filed the review petition, you have not challenged it before the Supreme Court. Again, the same prayer you have made in this, that lease may be granted. And with all these observations that you have enclosed the forest land, you have taken the water pipeline through the forest for 1 kilometer and some odd distance, drawing water illegally. Maybe that 2ECC proceeding might have been that is not a ground for giving you relief in this writ petition.
May I just place this this way? The affidavit was misleading and misrepresented, fully misrepresented facts.
Which affidavit?
They filed by the government.
You
and I have annexed.
Filed rejoinder affidavit. You have not done. You have filed the review petition.
My lord, I agree. My lord,
how can you say?
My lord, I agree there. Well, Lordship may kindly turn to pray. I may draw your Lordship's attention to section 38 of the Bharatiya Sakhya Adhinam.
We are not going to your.
Why?
May I just draw your Lordship?
Why it is applicable to this?
My lord, they have made the all false accusations and misrepresented
under this act now.
My lord,
is it under this?
No,
this has come in 2023.
Even Evidence Act has a parameter provision of section 40. Your Lordship kindly have that.
If somebody has made a misleading statement in the counter affidavit by virtue of which an order has been passed, review provision is very much there for that purpose. You have not availed that. You have not filed either any rejoinder affidavit. You kept silent. You filed another writ petition. So how can one division bench take a contrary view when that order has reached finality.
May I just-
Same prayer.
May I just take your lordship to page 118? This is another division bench order.
This is the latest one.
But this is after that.
Yes.
Madam.
No, in this before this division bench in 2023, is this order been brought to the notice of this that court that such an order has been passed? My prayer has been torn down for grant of lease. Then it amounts to suppression.
In 6579 2023, that fact was suppressed.
So, part the learned counsel for the petitioner, learned counsel for the state. This writ petition has been filed by the petitioner so and so with a prayer. Take down the prayer. It is the contention of the learned counsel for the petitioner that while passing the impugned order under Annexure 21 on 13/12/2023, the collector has rejected the prayer of the petitioner for settlement of government land available in Khata number 126 bracket AGA in village Topadihi, mainly on the ground that the lease proposal could not be materialized in view of the complaint received from one Ramesh Prasad Sao, mines owner, that the proposed lease area is coming under his surface right of leasehold area, and some of the plots are found as Sabi Kisham Jungle in the remarks column. However, the said land is under the encroachment of the petitioner, Messrs. Deepak Steel Power Limited. The land counsel for the petitioner, Mr. Rath, submitted that so far as the complaint from Ramesh Prasad Sao, mines owner, is concerned, that land which has been allotted to him has already been excluded, which would be evident from the order passed by the Tahsildar on dated 16/5 or 6/5, 6/5/2009, Tahsildar Barbil, by Annexure 6. And so far as the forest land is concerned, the authorities have given permission to the petitioner to establish the steel plant, and it has been made functional since 2009. And therefore, at this stage, in view of the order passed by the collector and district magistrate Keonjhar, the petitioner will face immense difficulty if he has to close the plant. The learning counsel appearing for the opposite party, number 11, Odisha Mining Corporation Limited, by filing the caveats as entered appearance, and submitted that the said land has already been allotted to opposite party number 11 since 2021. And earlier, the petitioner approached this court for similar relief before this court in WPC number 28605 of 2011, which was disposed of on 24/2022. And while disposing of the writ petition, the division bench of this court take into account the affidavit filed by the opposite party number 4, wherein it has been mentioned that without waiting for the permission from the Government of India under Forest Conservation Act 1980, the petitioner had gone ahead and established a sponge iron plant over the forest land, and that forest land in Sabi Kisham have been converted by the petitioner to non-forest land after 1980 without complying with the Forest Conservation Act 1980, and the petitioner appeared to have even laid a water pipeline within Siddhamal Reserve Forest of a length of 1775 meters for drawing water illegally from Karo River for the sponge iron plant. And further stated that a forest offense case has been registered against the petitioner as a result of the above violation. The order further reveals that though this counter affidavit has been filed since 2011 December, but no rejoinder affidavit has been filed. Accordingly, the court came to the conclusion that the prayer of the petitioner that for grant of lease in respect of the land in question on a formal basis or to get the IDCO to transfer the land in question in its favor cannot be accepted, and accordingly the petition was dismissed. The London Council for the petitioner submitted that the forest offense case which was instituted against the petitioner has been quashed by this court. What is that order?
In CRLMC.
In CRLMC number? In WPCRL number 1215 of 2011, disposed of on 31/1/2012. The London Council for the petitioner further submitted that thereafter another writ petition was filed before this court by the petitioner.
May I just please, my lord, at page 138 of the last
Just a
order.
minute. Which is that order which you are showing?
118.
118.
Last 138 is the order, it has been mentioned.
In WPC number 6579 of 2023, which was disposed of by the division bench in on 3/3/2023, wherein this court directed the authorities to consider the phrase representation, if any, filed by the petitioner by 10th March 2023, and further directed the status quo to be maintained till 2 weeks after the result. 2 weeks. And further direction was issued that in the event no representation has been made within that time, the order of status quo shall stand automatically vacated. It is the contention of the Land Council for the opposite party number 11 that when the petitioner filed WPC number 6571 of 2023, the order passed by this court in WPC number 28605 of 2011, which was disposed of on 24/20/22, has not been brought to the notice of that court for which such an order was passed. After hearing the London Council for the petitioner and going through the documents filed,
Thereafter,
and the impugned order passed by the London, we find no infirmity and illegality in the order, particularly when the petitioner has neither filed any rejoinder affidavit nor challenged the order passed on 24/20/22 in a review petition. I've got a line like this. Land Council for the petitioner submitted that the counter affidavit which has been filed by the opposite party number 4 in WPC number 28605 of 2011 has not reflected the correct state of affairs, and it contains misleading statement on the basis of which the said order was passed. Since it was open to the petitioner to file a review petition or challenge the order before the Honorable Supreme Court, and the same having not been done, and when this order has been attended finality for the self-same prayer, we are not inclined to accept another writ petition, and accordingly, the writ petition being devoid of merit stands dismissed. Yes, next.
May I pray, my lord, your lordship, on the basis of that certification, your lordship might review disposing
We
of.
have stayed already highlighted something. You can take it.
My lord, in 138 in the order, it has been reflected. Anyhow, my lord.
Next, yes.
Item number
Let-
6.
Yes.
I'm for the opposite party caveat only.
So, Mr. Deepak Guchal, Mr. Pari. What about item number 6? Mr. Guchal is there.
Last order, your lordship.
Last
My
order.
lord, item 6.
Yes.
May I audible, my lord?
Yes, of course.
My lord, item 6, I pray for time because last occasion also I took time. It is a case where he's claiming that he was the chief superintendent working for some period, but this period from 14 to 17, he didn't work in this post because his disciplinary proceeding was initiated against him.
Pari, the problem is that he has already filed a contempt petition for non-implementation of that order. And
Exactly. Yes, my lord. So
it
I'm
some
1
time.
or 2 days, only 1 or 2 days I'm praying this.
Okay.
Day after tomorrow.
All right, Mr. P.K. Padi, Learned Deputy Solicitor General of India for the court, prays for an adjournment for 2 days. This matter on it will come in the supplementary list on 6th of November.
Obliged, man. Obliged. And along with Deepak Gochayat is appearing with me, let me reflect her.
That is so and Mr. Deepak Gochayat, Learned Central Government Council.
Obliged.
Item number 7.
May I please, your lords. The petitioner filed this application challenging the illegal and arbitrary action of the opposite party, more particularly resumption of a land to the government khata without any proceeding, my lord. Kindly see Annexure 1. Yes.
Have you given a copy to
Your
the
lord. I will serve the copy.
The Land Council for the petitioner saw a copy of the writ petition on the Land Council for the state during course of the day.
Your lords.
During course of the day. This matter will be commencing from 11th November 2024. Yes.
Obliged.
Item number 8.
May I please, your lordship, my lord, in this case, I filed a IA for amendment and already I have served the copy, my lord, to the.
What amendment you want?
My lord, initially I filed this application before the Honorable Single Judge, my lord. Thereafter, it is referred your lordships, my lord. So.
You want to add some paragraphs?
And also praying person.
Prayer you want to change?
My lord.
So have you gone to Mr. G? Have you gone to this?
Yes, my lord.
Any kind of objection you want to file?
My lord, the lordship may kindly see the prayer. But he wants to add.
No, not only prayer, he wants to add some paragraphs. And also change the prayer to some extent. So if the nature of the writ petition, the character do not change, then the matter is different. Otherwise, he can seek liberty to withdraw it and to refile that can be done.
May call this matter tomorrow.
Just examine it.
Yes, exactly.
All right, IN number so on. So the Learned Additional Government Advocate submits that matter may be taken up tomorrow. Stop. Put up this matter on 5th of November 2024. Yes.
Item number 9.
29 fellowship directed
Yes.
for the file the seniority and death certificate, lordship. Thereafter, I have filed 30th 10, lordship.
You are for the petitioner.
Yes, lordship.
Which has been filed in this case is a wrong one, and you may be given some more time to file a correct one after serving a copy and the land. Yes, you have filed it.
Yes, 30th
Okay.
I have filed.
And you have given a copy to the.
Yes. Let it
Yes.
come on 11th, lordship.
You want it on 11th. So who is for the Central Government Council, Mr. Padi? Mr. Padi, in item number 9, a phrase synopsis.
Unmute yourself.
Please unmute.
Unmute yourself.
Have you been served with a copy of that phrase synopsis?
No. They might have filed the code, but we didn't have received that copy of the synopsis. The noting is there.
They have received the copy on 30th.
You say that it has been served.
Yes, I will also copy served today.
So, are they not granting any receipt to you?
Not received.
No, whatever document they are filing, we are issuing the receipt. It's not that we are not.
Say that no receipt is granted by your office. That is the complaint.
No, we are giving the computer receipt, my lord. At least we have come to that stage now.
All right. So, he will give you another one.
Yes, my lord, I have served the copy.
Today, the Land and Council for the petitioner submits that he will serve a copy of the press synopsis to the Land and Deputy Solicitor General of India, Mr. Padi, by tomorrow.
Today.
During course of the day. Okay. You want it next week?
Next week, 11th.
Okay. Put up this matter on 11th of November
2020.
Also reflect Mr. Guchhat's name along.
And Mr. T. Guchat. Okay. Central Government Council.
Item number 10.
Challenge. Next short 4, that is the order passed by additional sub-collector Bhubaneswar.
Get the mic, kindly. Kindly come on the mic.
Use the mic.
The petitioner has challenged the order passed by the additional sub-collector Bhubaneswar before this honorable court, and if you lordships can peruse the order at page 34, the appellant purchased 1 acre land, Tahsil Sabik plot number Sasansaj from Durga Pada Bose Jaban by the arrest number 3277 dated 84/1983. The submission of the appellant is to record the HAL plot number.
You are reading from which paragraph?
Page 34, my lord.
Yes, 34.
First paragraph.
First paragraph.
After 4 lines, the appellant purchased 1 acre land of Tahsil Sabik
0.1 acre. 10 decimal.
10 decimal.
10 decimal.
From Durga Pada Bose Jaban by the arrest number 3227 dated 84/1983. The submission appellant is to record the HAL plot number 3262, HAL 405, and correspondingly to the Sabik plot number 785-120 in his favor, my. And in the next page, my lord, the Honorable High Court, while disposing the objection number 9.
No. Next, what is the next paragraph? Go to the next
last paragraph.
No.
Just don't skip it over. Just read it out. It may be against you.
In status report.
In status report, it is indicated that the Sabik plot number such and such stand received in favor of a government Anabadi Khata number 245. The HAL plot number 3262, HAL 0324 corresponding to the Sabik plot number. This stands in favor of a government administration department. The Honorable High Court, while disposing objection number 9449 of 1993 dated 29/196, directed the state government to inquiry into the matter through a senior officer in the rank of secretary whether the Tahsildar has settled the land by misutilized power then necessary legal and administrative action should be taken against the Tahsildar. And further, if the land is so settled, one used other within that purchase, government should proceed against the lessee in accordance with law. That is the order they have passed, my lord. On peruse of the case record, it is
Ascertain that
the order of the Tahsildar is WLL number 9673 has not yet been inquired by the senior officer in the rank of the secretary implementing the order of the Honorable High Court in OJS number 949 of 1993. In view of the foregoing decision, I am not inclined to record the land in favor of the appellant and the prayer of the appellant in appeal number this is disallowed. That is the order, my lord.
Yes.
Against this order, my lord, one Mr. S.K.Sahoo has approached this honorable court in WPC number 7511 of 2012, my lord. I'm placing the order.
No, this order, this appeal was
This
filed.
similar matter as before this honorable court.
This appeal was filed by one Gopinath Puhan,
My lord.
which would be evident from Annexure 4
My lord.
in the first line, that it is under 22(2)(b) of the OSS Act. So on.
My lord, he is a subsequent purchase.
So against this order, why another person would file petition?
Because he has purchased the land from that Bosman, who is the Jawan. He has allotted the land by the government of India.
Okay.
So he subsequently sell the land to Mr. Puhana, and Puhana is now in physical possession of the land, my lord.
Oh, so that Jawan sold the land to that person. Puhan sold to you.
No, he is present petition. Now Gopinath Puhan is the petitioner.
It is now in the possession of Puhana, and the land is not recorded in his name. That's why he is coming to this court, my lord. That I am blessing the judgment of this honorable court
in
case of Rajanikanth Sahoo and others.
To whom that Jawan sold that land?
Jawan sold to Gopinath Puhan.
The petitioner.
You sold it to that.
I have not sold.
The present petitioner is the Gopinath Puhana. Gopinath Puhana purchased the land from that Jawan. My lord.
But the land was
not settled in his favor because this honorable court in the OJC number so directed the government to inquire the matter by officer not less the rank of secretary. The present will case has not been inquired. Therefore the application of the petitioner was rejected. My lord, may kindly direct the secretary to inquire into the present will case.
Similarly situated case, my lord, I am just placing the judgment of this honorable court at page 4, internal page 4, paragraph 6. From the above judgments, we find that direction upon state made Sri Sharad Kumar Sahu to initiate a probe, and the direction upon state made in case considered in Uttama versus state appear to be the same. We are in respectful agreement with the view taken Uttama versus state in that the direction did not require state to initiate probe in all lease cases. In all these cases, it is a blanket order of this honorable court to probe all the cases. Now, this division bench said that it is not necessary to probe all the cases by the top officials.
This case, whatever has happened in the other case, we do not know.
Yes.
Particularly in this case, there was the order of this court is there, which you have just placed that and the inquiry was directed, but what has happened
in the present will case, WLL case, inquiry has not been conducted. That's why the authority rejected the appeal, my lord. And revision also provision is there.
Yes.
And also in a similar case, exact Jawan case, my lord, another judgment of this honorable court in WPC number 2207 of 2001.
This
exact case.
provision for
revision, my lord. 25 revision. This under section 22 of Orissa Survey and Settlement Act.
Very same
That
and
is
similar. Same Jawan, same land, adjacent to the land. Yeah.
Have you filed the copy of the lease?
No,
Copy of the lease in favor of Jawan.
that is not annexed.
Where is the condition that he can sell by within what period to whom? What is the condition?
And
Can
which
the land be
purpose it was
subject to sell? Whether the land allotted in favor of the Jawan is subject to sell, sublease or sell. If it is so, then within what period? Is there any time limit?
Taken from the competent authority trying to sell, and competent authority has allowed him to sell.
Are you having that copy or you want to
Lease copy.
Lease copy,
lease
not me, I have to file lease copy. They are giving the similar order, my similar job already court directed.
By showing this similar order, many things have been the petitioner so has filed this writ petition with a prayer to declare the resumption of the restoration of the land in question to government khata by settlement officer, public assistant settlement officer, public additional sub collector is bad in law, with a further flair to quash the order dated 22/4/2021 in appeal case number 88 of 2016. The Land Council for the petitioner submits that the petitioner purchased the land from
Durga Pada Bose. Durga Pada Bose.
Yeah, Durga Para 3. Para 3 of the writ petition. What changed to name? Durga Pada Bose. In
the land in question was settled in favor of Durga Pada Bose. Page number 34 with Jawan in WLL case number 961 of 1973, and the petitioner purchased 1 acre of Tahsil
10 decimal. Acres from 10 decimal.
10 decimal. 10 acre sum 100 decimal of Tahsil Sabik plot number 1 so joda lekha hai the Land Council for the state raised a preliminary objection that against the impugned order, revision is maintainable. And when we put a pertinent question to the Land Council for the petitioner as to whether he is having a copy of the lease which was granted in favor of the said Jawan, and whether the Jawan has been granted permission to sell the land in favor to anybody, to anyone. The Land Council for the petitioner seeks some time to obtain necessary instruction put up this matter, and we commencing from 11th November 2024.
Item 11.
Maybe
item 11.
11 to take.
Let it be on 18th.
But
So, Lordship, may kindly see the order dated 11/9/2020.
my lord, item 11.
Yeah.
I'm sorry, my lord, Mr. Bimbisar Das is allotted to this case. Today, he joined in this state panel.
As of matters.
Today, I am entering appearance. Let's make keep to next week.
All right, Mr.
After 10 days, it's better.
Okay, Mr. Paril and Deputy Solicitor General submitted that Mr. Bimbisar Das, who was the senior panel counsel for Union of India, and he has been now the additional government advocate, and therefore either he will do this case or he will entrust it to be to someone central government advocate to do this matter. The matter may be taken up next week. The Land Council for the petitioner objected to such adjournment, be that as it may. in view of the submission made by the Land Deputy Solicitor General, is this matter on Mr. Padi, it will be on 11th of November.
Yes, ma'am. Fine.
Yes.
11.
Item 11, 17,
No, similar.
18,
There are
19.
similar petitions.
All are batch of matters.
Right.
My lord,
List this matter.
arising out of
List this
11,
matter.
17.
11, 17 then.
17 to 25 except 24.
Acha, 11, 17 to 25
Except 24.
except 24. है ना? Same submission has to be put down and it is to be placed on 11/11/2020. Okay. Next.
Item 12.
Well, my lord, I pray for 2 weeks time. No interim order is
No, Mr. Goswai, you just folded your hand. It's not good. Just make.
and that
submission.
is a habit I have
no.
formed. I have
Don't
formed.
do it. Do it.
I will not suffer then.
You want adjournment.
A habit is
No,
formed.
no, it's not. It's not. You want adjournment.
My lord,
Till
2 weeks time.
2 weeks. Mr. Bose and counsel appearing for the petitioner, 6 for an adjournment for 2 weeks. Let this matter. We come and see from 18th November 2020. Yes.
Let in court my habit
It's
is
all right.
formed.
No. It's not. Just make your submission.
Item 13. On behalf of Advocate Mr. Asutosh, Mr. Pray for adjournment, my lord.
You are for the petitioner.
Yes, my lord.
Adjournment, any order was passed in this case?
Order of Tahsildar was challenged
The
revision.
petition challenging the Annexure 2, my lord. That is order dated
The revision
28/6/2024,
Order of the regional authority.
my lord.
So
It is the same one that the manner you were saying.
My lord,
This is the regional authority.
this is, yes, my lord, revisional authority. And in this case, in the year 1983, the lease deed was cancelled. The petitioner purchased the land in the year 2011.
connected to the other
No,
matter?
no.
Independent.
Okay, the Young Council want adjournment. We should not say no to that. So you want it next week?
Yes, my lord.
All right, the Land Council for the mention is made on behalf of Mr. Umachar and Misro for adjournment till next week. Please this matter on 11th November 2020. Yes.
Oh, please, my lord. Item 14.
Bimbi Sardas.
14
Item 14 also same. I will enter appearance. I will appear in this case. But some time, 10 days time may be given.
Government advocates. So, how many of your council has been taken over by?
About 20, my lord. About 20.
All right.
Cat and I could both.
Item 15.
My lord,
Item 15, I've gone through it last occasion, my lord. Instruction opted instruction. But I'm sorry, my lord, I have not enlightened my lord. They have made personally all the party. Anil Kumar, Lauti, chairman, railway board. Then they have made a Manoj Sharma, general manager. By name, they are in the opposite party. The read is not maintainable against the private opposite party. It is not coming in Article 12. Everybody is all the opposite by name.
Against the order of the Honorable Cat, my lord, I have approached my lords. They have the decline to.
All right, for Union of India represented through such and such, and the railway would have been there.
My lords.
You have met everyone.
Why?
Personal party.
Because you see, suppose the person is today is there in that particular post. He may, someone may retire, someone may go to the other department or assign some other. So today he is general manager. That does not mean that it has been passed in his personal capacity. As a general manager, he has passed the order. So you are an experienced counsel. Why have you mentioned all these persons by name? When he has been passed the order as the official capacity.
The Honorable Cat, Lord Cat has directed that the opposite parties be implemented. So that's why.
No, the objection that has been raised, that why are you making them by name you have made as opposite party? It's not a contempt proceeding. It is a just you are challenging the order of some authorities. So you are to mention the name that just general manager so and so.
Because
Those who
Sharma
have
is
been
nobody is
taken
an
in the
adjournment.
contempt petition have been taken as the opposite parties in the.
Exactly. Exactly. My lord is correct.
So you do one thing,
Contempt
you
is
just either change this, make
Cost
the
title.
cost title corrected by filing an
it is better to withdraw it and file a press
we are
application.
giving you permission to file a better one. So
My
that there
lord,
will be no difficulty and all these
yes.
documents will be returned to you.
My lord, that the opposite party, the railway authority, I will include them as a party.
अरे
And
बाबू ये ना गुड़ा काटिबे कोन मा दे
हाँ हाँ my lord
सेती तो करिवे
हाँ से एटा को अमेंडमेंट करके मु गोटे मिसकेस करि देबी
आउ भितर ताको ना लेखि ना दी कोडी
नहीं नहीं अब कहार ना लिखि नहीं सेटा 1 2 3 4 जे तरुणकर मनोरंजन सीट पर्सन आ my lord से तबरे 7 पर्यंत अछि आ अन्य कहार ना नहीं से आ अन्य प्राइवेट अपोजिट पार्टी जे कहार देनी
ना ना प्राइवेट अपोजिट पार्टी अपन अलगा कथा
हां
इगुडा सबु तक सी मिस्टर पाणी को कहया कथा ई जो मानकर ये क्वेश्चन इवन सब ऑफिशियल कैपेसिटी रे अपन ता ना लिखे यदि कि प्राइवेट अपोजिट पार्टी ना दिसी सेया कहउचंती
प्राइवेट अपोजिट पार्टी ना
GM is changed. Mr. Sharma is nobody is GM. Some else has been joined.
तो
To whom I will obtain instruction.
मनोज शर्मा से कहउचन बर्तमान ना दिसे पोस्ट रे ता ना कोन लिखि देले तो हु विल फाइल द काउंटर एफिडेविट अरे से ही से
But I will change the cost title by filing a miscase file before my lords.
all right a preliminary objection has been made by the Land and Deputy Solicitor General of India to the naming the opposite parties, describing the opposite parties by names. The Land Council for the petitioner seeks some time to file an interim application for change of the cost title and seeks for an adjournment. Put up this matter in the week commencing from 18th of November 2024. If any interim application is filed for such purpose, let a copy of the same be served on the Land and Deputy Solicitor General.
Consulted it petition may be filed, it will be better.
No. As that permission is to be granted, he has
only cost title. I will
he only just change the cost title.
Cost title.
That's why I am consulted.
Once it is allowed, then he will be
Exactly. Yes.
So the matter will come, Mr. Pali, on 18th November 2024.
Obliged, man. Yes.
Obliged.
Mr. Gochayat appearing with me. Let's move.
Yeah, and along with Mr. Gochayat, for example.
Obliged.
The Land and Central Government Council. Yes.
Item 16.
Item 16 in this case, I am appearing for the opposite party 1 and 2 and also the counter already filed on 2010-2024 and copy already served to the applicant's petitions counsel.
Which for the petitioner?
The petitioner is
Mr.
Ms. Shashwati Mahapatra.
Yes, rejoinder is also in file.
Rejoinder file is you.
Annex
No,
7.
this is for first time come after my appearance. It has come.
Annex 7 is the
rejoinder to the counter file.
Not 28-10 file. Just
it is.
But your counter is not placed on record.
Because of on 28-10 I have filed and hard copy filed.
That a submission is made on
Rishikesh Tibet.
Rishikesh Tripathi, na? Land Council appearing
Kendra Vidyalaya Sangathan, opposite party 1 and 2, all opposite parties.
For the opposite parties, that a counter affidavit has been filed on
28-10-2024 and copy also served on application
on the Land Council for the petition.
On the same day, on 28-10.
On the same day. Let the registry place the counter affidavit on record. None appears for the petitioner. Stop. List this matter in the week commencing from such answer date. Rejoinder affidavit, if any, to the counter affidavit we filed in the meantime, serving a copy on the Land Council for the opposite party. The sabta for yes.
Obliged, sir.
Item 24.
Yes, item number 20.
My lord, though the petitioner, my lord, has lost their land and their entitled for, my lord, around our benefit, rehabilitation resettlement benefit, but that has not been granted. To that effect, they have made representation before
Annexure 6 is
my lord, Annexure 6.
representation that is to be disposed of. Annexure
24.
item number 24.
24.
Okay. Yes, next.
Item number 26.
26 is Annexure 7, my lord. The same matter, that is Annexure 7 representation.
এটা হচ্ছে annexure ওটা দেখি লিখবি অলগা অলগা annexure ହେଇଛି
My lord.
দেখি representation টা ଦେଖିବେ କୋଉ annexure that is to be disposed of. Yes, next.
Item 27.
Mr. Amar Kumar Mahanti.
Item
You
28.
are having a copy of that?
Yes, yes, sir.
So pass over.
itu representation এটা representation ଯୋଉଟା ସେ pass over କରିବେ
এটা representation টা pass over କଣ ହବ?
representation
Page 20.
there is a representation
So you ଲେଖି ଦିଅନ୍ତୁ the annexure 7 to be disposed of. Yes, next.
Page 20 annexure.
Item 28.
No. 26 ରହୁଛି 26 का representation.
27 sir
27.
26 item 26
26 ହଁ 7 ରେ ପଳେଇ ଆସିଲେ ହଁ ତେଣୁ 26 ଟା ଆମର ଆସିବ
26
ହଁ 26 ଆସିବ
26 ଟା ପୁରା pass over ହେଲା
ଏବେ ଆମେ କୋଉ
ଏବେ କର
26 ଟା enter the bank minutes.
ହଁ ଠିକ ଅଛି.
The account has been upgraded minutes.
You are placing now 26.
6
Okay.
Enter the bank.
What is your submission?
Submission, the account has been upgraded minutes. So there is no number. It is infectious.
infectious
Right.
account has been updated
Just give the name so that any kind of document are you filing?
Document plus instruction. My instruction that one.
So the writ petition has been filed with such and such pair for appearing for the bank, State Bank of India. Submit that the account. It has already been settled or what?
upgraded
The account has been-
We have paid around
the
10 lakhs of
account has been
rupees.
upgraded, and therefore the writ petition has
It is standard account. Standard account.
the writ petition has become infructuous. In view of the submission, the writ petition is disposed of.
We have filed a petition for one-time settlement.
When it is a PM minutes, the question of one time does not have it is not NPM minutes.
So the prayer now which you are making in this writ petition, that has become infructuous. That is the submission. It is up to you to do the needful. Yes, next.
Okay.
Item 28.
27 Annexure
representation
yes, Annexure 7.
annexure 7 ଏଟା କେତେରେ
27.
27 ତ ଗଲା 7
27 is over. Representation disposal.
28
28.
Lordships, the petitioner has taken a loan of rupees 20 lakhs 20.
Lordships, the petitioner has taken a 28 lakh rupees loan from the bank and has returned the money for 15 up to 15 lakhs rupees. Now the petitioner up to 15 till COVID. So after COVID, he was running a business firm which due to COVID broke down and he lost her husband in the meantime. So
sale notice has already been issued.
yes, sir,
Sale was fixed to 30th. I am for the opposite party bank. I have to take instruction.
we are
No instruction. This
so already
DRT is approached to DRT.
so we are only issuing to this.
The Bofna Motors, paragraph number 110.3. Disposed of is at liberty to oppose the alternative limit. Prayer. Yes, next.
My name may be recorded by
Not a motion. The council is appearing for the bank. Next.
Item 29.
Yes.
Cancellation of my lease agreement without any notice and without assigning any reason is the subject matter of challenge that your lordship had faced, and 23 is the rejection order, cancellation of my lease order. 23. Yes, madam. With reference to the subject cited above letter, it is to stated that the office of the undersignee had previously intimated you about non-feasibility of the land allotted in your favor by letter under reference, and also informed the same to the higher authority of the IDCO. Accordingly, basing on the feasibility of the land, subsequent order of so and so, the allotment of IDCO land is hereby cancelled. This follows no notice, my lord. The briefly, I am stating that district level single window clearance authority has recommended for allotment of a piece of land for industrial purpose. Now, on 7/9/2021 at Annexure 2, the
No,
IDCO...
you mean to say for this cancellation of allotment,
Yes, my lord.
no notice has been issued.
No notice has been issued. And the reason is also not...
he has referred to some letters, SD letters number one so of...
But no so-called whatsoever.
And so,
may I just take through the facts, my lord?
No. That have you taken that ground in?
Yes, my lord.
Where is that?
It's very fast.
Okay, you have stated that
In paragraph 1 itself.
Principle of natural justice, no opportunity of hearing was granted from considered model of responsibility. With the opposite party?
IDCO, my lord.
They have a panel council or
no notice.
IDCO रखिए अपन
IDCO panel council के ना notice है तो प्लस ना many है
किया चंदी
senior advocate PK
Pradeep Mahanti. He used to appear for IDCO. He buji कहलाम दा ना लिखी दो so that he appears.
Senior advocate Gautam.
All right, it is stated
Gautam Kaj is also
Mr. Pradeep Kumar Mahanti, Pradipta Kumar Mahanti, and a senior advocate used to appear for IDCO. Let a copy of the writ petition be served on the Land and Council during course of the day. Matter to be listed day after tomorrow, that is on 6th of November 2024. Indicating the name of the land senior advocate in the corridor. Yes.
obliged.
Item 30.
Item 30.
There is a delay of 304 days, and there is a defect also. So far as delay is concerned, you are for whom?
I am for the sole opposite party, my lord. The commissioner as well as my lords have directed to record the case in my favor. Since the Tahildar did not comply the order, we have filed the writ application and it was directed to Tahildar to correct the record. Now the Tahildar has filed the writ application challenging the commissioner order and the order of the official.
There is a noting that there is delay of 304 days in filing this writ appeal.
No copy has been filed to serve on me.
You have not been served copy. So have you have filed your powers?
Yes.
Yes, I will.
The interim application.
So I will serve it.
Next to the sir, more जमीन दो ना थी, more जमीन का पट्टा करो नहीं मना रही.
आगे मेरी टू परे जी आगे बड़ा को सॉरी जाओ. देखो Mr. Satyavadi Mantri, Land Council appearing for the sole opposite party submits that he has not been served with a copy of the writ appeal or the interim application that has been filed for condonation of delay. Land Council for the state submits that he will serve the copy of the writ appeal and interim application on the Land Council for the opposite respondent, the respondent of the opposite party. କେବେ ଦେବେ କାଲି by
Kalika by tomorrow.
tomorrow ଆସନ୍ତା ସପ୍ତାହରେ
ଆଜ୍ଞା
you are at liberty to file objection to that interim application
well, well.
next week on 11th of November 2024 the Learning Council for the respondent is at liberty to file objection if any to the interim application for condonation of delay. Yes, in the meantime.
Item 31.
May I please, my lord?
ଏଇଟା ବି condonation of delay ଅଛି.
My lord.
31 and to the opposite party. So far as the delay is concerned, I do not have any objection because it is squarely covered.
Just a minute. IA number so and so. There is an application for condonation of delay. So you are the sole opposite party.
We are for the licensing.
Just a minute. Petitioner is Nusinga Charana Kunde. So how many opposite parties are there?
1 to 4.
4.
You are appearing for all of them.
All.
The Learning Council for the opposite parties respondent submits that he has no objection for condoning the delay in filing the writ appeal. After hearing the Land Council for both the parties and going through the arguments taken in the interim application, and since the Land Council for the respondents has no objection in the condonation of delay matter, the delay in filing the writ appeal is condoned, and accordingly, IA is disposed of. Yes, what is this writ appeal for?
My lord, but here the respondents are unauthorized occupation.
Where one of the member and the division bench, Mr. G. Suspect is a member. Justice is Petition has been disposed of by so and so years. After disposal of the above writ petition, an interim order bearing so has been filed for recalling the order so and so. The matter, if approved, may be listed before a division bench where so and so is a member. Praise the favor. अच्छा अप्रूव करो अच्छा जो ऑर्डर पास कले अन्य बेंच एटा अन्य बेंच को जीवो जोटा सेटा काटी दियंतु peruse the note of the Honorable Chief Justice wherein it is mentioned that the matter is to be listed before a division bench where Honorable Chief Justice G. Satpathy is a member. Registry shall take necessary instruction and this will matter before appropriate. This is item number 30. ये जो हमें अर्जुन कोर्ट में 11 a condonation of delay condone gala now writ appeal. Yes, writ appeal कौन?
The respondents
in this writ appeal?
Prayer is for compensation, my lord.
No. Which order you are challenging?
Challenging the order dated 24th
order dated
24th February 2020, my lord.
Mike critique phone to
My lord, order dated 24th February 2020, my lord.
31 January. Your time order. Soon to 315. Order. 315. 30 is all right. 15 now is that.
Seriously, you order pass.
ठीक अछि. Now 31 will go.
So, Mr. Counsel, we have to delay condonation be
करियो.
This matter has to go to a division bench where Honorable Justice G. Satpathy is a member, right? Because the earlier order was passed by a division bench in which Justice G. Satpathy was a member. So that is how the order was passed. Registry should not have list this matter before us, right? It has to go to a division bench where Justice G. Sarpati is a member.
Mine.
Honorable. Yes. So the order to Adil Kar, right?
Item 32.
Wait, please, my lords.
My lord, I am filing my objection to the. I had undertaken last time that I will file objection. I am filing the objection today. I have served copy to my learned friend.
It's a application for condonation of delay.
My lords, there was a.
By the way, what is the delay period?
But it's 23 days, my lord.
According to me, my lord, 687 days.
The stamp reporter must have pointed out, my lord, 23 days.
Stamp reporter may have given a wrong.
Right.
My lords, I have given my objection. Let my learned friend go through that.
Where have you stated that the stamp reporter has incorrectly pointed out that?
My lords, I have said that.
In which paragraph, Mr. Rao?
Paragraph 4.
Paragraph 4.
4 last line good there. In view of this, it is to be seen as to whether the restoration fiction was in
At paragraph 4, my lords,
on
that after about 687 days from the date of the dismissal of the writ application, that will be writ appeal, my lord. The present interrogatory application is filed on 14/8/2024 under Section 5 of the Limitation Act, praying therein to condone the delay of filing the restoration application on 18/11/2022. In view of this, it is to be seen as to whether.
Oh, acha, acha. जो दिन restoration file कले से दिन ये interim application का file करो.
Like after about 2 years after the interim application has been filed.
IN number 1, this is an application for condonation of delay. The stamp reporter has pointed out that there is a delay of 23 days in filing the CMAPL for restoration of writ appeal number 222 of 2015. But Mr. Jayant Kumar Rao, learned senior advocate, and filed the objection to such application, wherein it has been mentioned that the stamp reporter has incorrectly indicated that there is only a delay of 23 days in the filing of this CMAPL. In fact, it would be 687 days. He has mentioned the reasons in his objection. The copy of the objection has been served on the Learned Council for the petitioners who let the registry place a note on this objection. The matter will be listed in the week commencing from 18th of November 2024. Registry to place a note on this objection, which has been filed for. Yeah.
Item 33.
My interim application have rendered infructuous because I have filed application to permit the petitioner to appear in the written examination, which has already been held on 3/11/2024.
IA number so is an application for a direction so. As Nepali Mahapatra Land Council submits that the intake does not want to praise this interim application as it has become infructuous, and the petitioner he has appeared over.
Well, Lordship,
Yes, filed in-
the application could not be taken up, my lord.
Yes, filed in April, May.
All right.
Let copy.
The writ petition is accordingly disposed of.
Naimo?
Nine.
Writ petition টা আলগা।
Writ petition টা আলগা prayer.
Writ petition prayer.
Retriever will file the counter for each time.
I Mr. P.K. Mahanti, land senior advocate. Would I would want matter upon you there are କେତେ number ଆପଣ କହିଛି ଗୋଟେ
या ଗୋଟେ ଆଉ ପରେ ଅଛି
ନାଇଁ ଆଜି ଗୋଟେ ଆପଣଙ୍କୁ 2029 ରେ ଆପଣ appear କରୁଛନ୍ତି କି ଏମାନଙ୍କ ପାଇଁ ଯେ submission ଇଡକୋ ପାଇଁ ଆପଣ appear କରୁଛନ୍ତି
ଇଡକୋ ପାଇଁ yes
the copy ଆପଣଙ୍କୁ ଦେବେ that has been listed that is the order. So Mr. P.K. Martin and senior advocate submits that will file his objection to the writ petition.
It is a very urgent matter, my lord. This is the petition that go, my lord.
No, he is saying about 33.
33.
That time we will file a counter. Our
counter केबे file करी
4 weeks time, lordship kindly.
4 weeks, my lord. In the meantime, my lord, the written examination has already been over. I am filing today, my lord. I am filing the application to keep one post to be vacant.
So matter registered in the convention from 25th November 2020.
Yes.
My lord. Counter is pending file in the meantime to the copy to the land council for the yes.
My lord, 33 item we don't have a copy, so I will.
That is 33.
State is the party. Copy.
ନୂଆ ଆସିଲେ ସେ ସବୁ ହଜିଯିବ ଆପଣ ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ କପି
ଦେଇଥିଲେ ପୁଣି ଆଉ ଗୋଟେ କପି
ହଜିଯିବ ବୋଲି ଆପଣ on the land council.
2 minutes here watching the time here, madam. Here they have madam put wrong questions. Question number 1.
It will be decided on 25th November. Yes.
25th time.
Yes, next.
Item 34.
Who is appearing for the worthy parties?
Yeah. Mr. Sharma has come.
Yes.
Mr. AG was to come in this case, as was submitted last time.
No, I am there, but actually the brief has been entrusted to my learned friend who has joined only day before. So it may, your lordship may grant a short adjournment, so that because I could also not be able to go through the brief by myself last night, the file was not there. So any date convenient, either 1 week after.
The submission was made that you are to argue this matter.
Right.
That will be the reason.
And that was the
interested in the learning.
My lord.
In fact, the court required after your lordships will have order of 2nd of January 24. And paragraph 5.
2nd of January.
Mr. Mohanty, learned, my lord has not. Mr. Mohanty, learned,
yes,
additional government advocate contended that there is a mistake.
Yes, that is there.
I'm sorry.
Let the learned AG go through. There are so many orders passed. There was some kind of proposal given, and all these things are there. So,
Lord, I'm not addressing the merits at all. What I'm only saying is that this court, my lord, has thought it
which is
appropriate.
Which is that order you?
My lord, therefore, I was just taking the lordships to firstly to one as to why this order of settlement was passed.
No. Just where is that order of settlement? Where?
Yes.
Which is that order?
That your lordships may be kind enough to see, Lord. 1st of March 24, my lord.
1st of March 2024. Let us go to that.
And followed up by other orders.
Yes, just a minute. 1st of March. 1st of March 2024. There is no order.
It was there.
In the 2017
the other order.
That's right.
WPC number 2600.
Yes, Lord. Yes, Lord. I'm so grateful.
2600 another connected matrix there.
से आरटा बाहर के लिए 26,000 तक बाहर कौन? 1/3/2024.
Another matrix there. Number next matter connected. This one.
Learned AG, please go through that order. That is the reason why the State Council.
What is the order date? 1st March.
1st March 24.
that order was passed in WPC number 26000 of 2017. Order is dated 1/3/2024. Yeah.
The basis of such reply affidavit filed by the opposition, all the parties are agreed to sit together and explore the possibility of amicable settlement of the dispute between the parties outside the court. That is referring to that. I'm aware of this order because certain orders have gone through. But I have to take also the instruction from the government
That
because
is
it's a
exactly-
mines matter. So I don't know whether the extra land can be given at
That
this
is
juncture
exactly
after
the-
so many.
that
That's
is it.
correct.
Or because
So
he is
that
not
is why.
addressing on merit only, the matter is adjourned from time to time. Only once you make a
Yes.
statement
Yes.
that whether the government can do it, cannot do it,
Right.
because the other opposite party say that we are not interested to sit there for because we are,
Right. Right.
it is up between the government and the petitioner. They
Right.
are to.
Right.
So get a clear
Well,
statement from
let
the
me discuss
government.
with the what is the in fact the background fact.
Lord,
Let
I,
me just
I think the learned age is right, my lord.
Right.
Let him get a
So
hang of the matter.
thereafter, if necessary, the matter will be hard on merit.
Right.
If it is
Right.
amicably settled, well and good. So, can it be taken up this month, or you want?
Let any day convenient to your lordship, bearing 2 dates because a batch matter has been fixed. This is December, November. Let in the first week of December.
Okay.
First
So
week of
let it
December.
come on 22nd then,
That's
or
fine.
you want it on in the supplementary?
Non-miscellaneous day. It would be on 4th, my lord.
Fourth,
better.
okay, all right.
My lord, could your
Because
lordships
my
be kind
lord-
enough to have it on the 6th, my lord, either on the
6th,
Sixth
there
is the Friday.
used to be a reshuffle. Sometimes,
or
whatever
my lord
single
9th
benches.
or 9th.
9th it can be made
Right.
possible. Why you say it on any date like Tuesday, Wednesday, like this date you said? Because the trace admission matters are coming on that.
So, my lord, we'll take our chance on the 9th.
Okay.
We'll
9th.
report to your lordships
All right.
where we are standing.
This much of instruction on that day you just
That's
give there.
correct.
All right. The Mr. Pitambar Acharya and Advocate General is present, and he submits that he has gone through the orders passed by this court, and he may be given some further time to obtain instruction from the government regarding the possibility of amicable settlement of dispute, which has earlier been reflected in the orders of this court. On consensus of the parties, put up this matter on 9th of December 2024. Mr. Ashok Mahanti and Senior Advocate is present for opposite party number 4. Mr. S.K. Pari, Land Senior Advocate, is present for opposite party number 5. Mr. C. Sharma, Land Senior Advocate, along with Mr. A.K. Mahanti Advocate, is present for the petitioner. All right.
Lord. In the meantime, my lords, we can take advantage of this time by sitting together. My lords.
Yes.
Item 35.
Item 35. We are the appellate, my lords. A counter has been filed, and we have to file a request. Any date, your lordship, I'll file it within a week. It's a Government of India corporation, so
The other side, Mr. Kanungo.
my lord, the other side is last time also they had not appeared.
Is it a
There
private
is a
opposite
thing
party?
to
Or?
serve the
Yes,
copy
it's a
of the
private
same to us, we don't know what is the department. There is a noting.
The department is Airport Authority and Ministry of Railways.
Ministry of Railways also we have supplied copy.
Then we didn't receive the copy of the any of from
The
our lord.
Ministry
If
of
my
Railways,
learned
we have already
friend will serve a copy, it will I will be grateful, my lord.
Government
my lord, I'll serve another copy.
And who is for that airport?
Aviation.
Airport Authority, if Union of India party, then we will appear. Previous occasion, I was entering appearance, but because they are not getting.
And with that private opposite party, Mr. Kanungo?
My lord,
Your lordship, I am for the opposite part number 1. Respondent 1.
You have received the copy of the. Oh no,
And the respondent already filed the
that counter affidavit has been filed by opposite party number 1.
Yes, Lordship.
Not
Well,
this-
actually, the fighting opposite parties, litigating parties are
the
the
opposite party.
present petitioner and opposite party.
Respondent one, number one. All right. Mr. Milan Kanungul and senior advocate appearing for the appellant submits that he has received a copy of the counter affidavit filed by the respondent number one, and he intends to file the rejoinder affidavit, and some time may be granted. The Mr. Padil and Deputy Solicitor General of India appearing for the opposite party number three submits that he is yet to receive the copy of the counter affidavit filed by
Well,
the
he's already
respondent.
received it. We will give an extra copy. He's already received their office. We'll
Can
give
you
an
give
extra
a reference of the date, my lord?
Let
No,
a
we'll
copy,
give
let a copy of
2310.
the so and so be served on Mr. Padi, whose name is to be reflected along with you, Mr. Padi.
Yes, Mr. Kashyap, S.S. Kashyap.
S.S. Kashyap.
Satya Sindhu Kashyap, yes.
Satya Singh Kashyap, Central Government Council. Yes. So when it will be listed?
Any day subject to your lordships.
It is better after 2 weeks, man.
Okay, after 2 weeks, what date? Yes.
Lordship, may kindly date fix.
Yes.
May kindly date fix. It's difficult to be list this matter due to.
No, it will be. We'll give the date. You will say in the evening hours. In the
Obliged.
High Court website, you will get the date.
21.
Okay.
2 weeks.
And this is to come along with that contempt petition. There is a contempt also.
Lordships, 21, 22nd, I'll not be there. 25th, in the week of 25th upon
Sure,
date.
25th for them.
I
25, 11, 20, 24. Okay. 2 weeks start begin. Corporate date for them. 25
I
Obliged.
oblige.
Item 36.
The matter petitioner challenges the judgment of the tribunal.
Who is appearing for the other side?
Sorry,
Who
it
is
is did it appeal?
Lordship, I am on behalf of the Mr. A.C. Ratha. Due to personal difficulty, he is not present today. Matter may kindly taken tomorrow, my lord.
Yeah, just a minute. This rate appeal, who are the respondents? OUAT. OUAT. So, you are mentioning on behalf of
Mr. S.C. Rath for
Mr.
OUAT.
S.C.
For OUAT.
OUAT.
Tomorrow.
Matter may kindly taken tomorrow.
Is there any difficulty tomorrow?
No, no difficulty.
All right. Mr. Manoj Mishra and senior advocate is present for the opposite petitioner. Mention is made on behalf of Mr. S.C. Rath to list this matter tomorrow, list this matter on 5th of November 2020.
Okay.
Obliged.
Item 37. Your Lordship, on behalf of Mr. S.K. Das, appearing for opposite party number 6A, B, and C. Your Lordship, praying for 2 weeks adjournment because there is a medical emergency due to which he is unable to come, Your Lordship.
Sushant Das.
S.K. Das, Sushant Kumar Das.
Your
Your Lordship,
You want adjournment?
Your Lordship,
What time you please tell us the time?
2 weeks adjournment.
She's saying that some medical problem was there.
No, I said that what is the time because she's the best
Should
person
fix
to
it
know.
because it difficulties.
2 weeks you want.
2 weeks.
So let it be on 25th.
Your Lordship,
25th.
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 Monday.
27th.
27th. Mr. S.P. Mishra and senior advocate is present for the petitioner. Mention is made on behalf of Mr. Sushant Kumar Das for an adjournment for at least 2 weeks on his medical ground. This matter on 27th November 2020.
Item 38.
I will plead your lordship.
My lords,
We are, Mr. Mishra, we are just coming within 1 day.
The petition of lordship.
My lords, this
Yes.
pleadings are complete, my lords. Lordship may fix a date because I need a better preparation, my lords.
Mr. Mishra,
14, I understand that predicament.
Kebera kya kaun?
14,
Yes, my lords.
he has some authorized difficulty. 14, not the civil fix no pick part.
And the proposition of the client, Additional Standing Counsel submits that he has been interested to argue the matter on behalf of state, and the matter may be taken up on some other day. Mr. Kaliprasanna Mr. and Senior Advocate has no serious objection to such prayer of this matter on 14th November. Yes.
Item 39.
39, my lord. Therefore, Mr. Mishra, I pay, my lord, 2 weeks, 2 days after, my lord. Some medical emergency has gone. He's not here.
One date may be fixed, my lord. Because it is difficult to get the matter listed.
My date may be fixed.
Mention is made on behalf of the opposite party. Mr. Tanmay Mishra.
My lord.
Mr. Tanmay Mishra to adjourn the matter for 2 weeks.
No, 2 days.
2 days.
Wednesday or Thursday.
Next week, better it could come next week.
This week. Matter will be taken up next week. Mr. Niranjan Pandal and counsel for the petitioner has no objection. Put up this matter will be commencing from 11th November 2024. Yes.
Obliged.
Item 40.
Next matter also, I pay, my lord, next week.
So he is asking for an adjournment till next week. Some health grounds. So we are keeping it on same date on 11/11/2024. Okay.
Item 41.
14.
11.
I'm for 3 and 8.
Mr. Bear, are you ready in this matter?
No, my lords, noting that your lordship has directed, sir.
It is state's writ petition.
Yes, my lords, I have not prepared. One order was lordship has directed on 8/8/23, which has not been complied. I'll verify that order, my lords. 8/8.
So you go through the ratio laid down in that Seboti Dei case.
My lords.
And see the prayer which you have made.
My lords.
It is the submission that has been noted down that the writ petition is not maintainable in view of the ratio laid down in that case. See if there is any contrary decision to that, or any Supreme Court decision. Okay. So it can be taken up next week, or you want it further.
Any day, lordship.
An order was passed on 8/8/2023, wherein the state wanted some time to examine the contention raised by the London Council for the opposite party that the writ petition is not maintainable in view of the judgment passed by this court in the case of Sebati Dei and another versus Kesamaji and others. Volume 66, 1988, Kotak Law Times 759. Mr. Prabhu Prashanna Behera and additional government, additional standing counsel, 6 for an adjournment till next week to examine. Put put up this matter, Louis commencing from 11th November 2024.
Item 42.
Yes, Mr. Mukherjee. None is there. Pass over to
Item 43.
43, Mr. Agasti Kanungo.
We are for the opposite parties. Postal department is for the opposite.
Mr. Fari, no one is there, so we are just.
Yes, we are also not file the counter. Let's give to some other day.
All right, Mr. Non-appears for the petitioner, Mr. Fari, and Deputy Solicitor General appearing for the opposite party submits that given some more time to file the counter affidavit. Put up this matter in the week commencing from 2nd December 2024. Counter affidavit, if any, be filed in the meantime, serving a copy on the Land Council for the petitioner, whose name is to be reflected.
Satya Sindhu Kashyap.
Satya Sindhu Kashyap.
S.S. Kashyap.
Yeah.
Item 44.
Department, I am for the petitioner.
Yes.
Sir, principal, where I
Start. You have gone through the.
Yes, yes.
Yes. Initially, I was appointed.
You have submitted synopsis of the case.
Yes. First page. I have given a lot of first page.
Yes, that is available. Yes.
What are the synopsis? But the entire trouble started with the right from the grade 3.
Grade. What is the prayer in this case?
To fix my seniority above the persons, those who are initially recruited below me and were given promotion as against the reserved quota.
They are the opposite party number 3, 4, and
3 and 4. So.
Pro forma opposite party number 6 or what?
6 retired.
6 retired. So 3 and 4. Who is appearing for these two opposite parties? 3 and 4.
Samir Mishra Parash. Samir Das.
3 only. 3. Okay. Yes, please continue.
Lord, my Lord, Lord, I was, Lord, appointed.
At present, you are the Sirastadar.
Yes, Lord.
In the Court of Lawrence Civil Judge Senior Division.
My Lord.
Commercial Court Quarter. Yes.
Lord, I joined as bench clerk on 3/1/1994. Junior clerk.
Junior clerk. What a date chart type of देलेनी अब सिनॉप्सिस में किसी डेट लिखा ही नहीं
सिनॉप्सिस तळवरे डेट चार्ट सिनॉप्सिस तळवरे डेट चार्ट
सिनॉप्सिस तळाची अच्छा हो हां अच्छे
लिस्ट ऑफ डेट एंड इवेंट्स
हां कंपैरेटिव चार्ट गोटे करछि
अच्छा हो ये
कॉपी अछि I joined 3/1/1994 junior clerk.
For the comparative test.
Opposite party number 3 joined on 19/9/97. And opposite party number 4 also joined on the same date. But this was opposite parties 3 and 4 joined on the special recruitment drive for backlog of scheduled tribunal. Then I passed departmental exemption on 1/12/1995. They passed on 7/12/1998. Serial number of one of the gradation list of junior clerk. I was placed under that documents. I will take your lordships. Whatever I am giving. Just, I was placed serial number of 103. Opposite party number 3 was placed on 106, and opposite party number 4 was 111.
Right.
Then next promotion is to bench clerk grade 3, my lord. They got promotion as per ORB rules, my lord, as against quota, my lord, on 29/7/2009 and 1/9/2010, and I got regular promotion as against general vacancy on the basis of my seniority on 1/6/2010. Then, my lord, the gradation list of grade 3 was, my lord, done. I was 121, they were placed 123 and 127 on the basis of the catch-up principles, my lord, even though I was promoted later. Then I passed date of passing of accounts training examination is 7/5/2014. They passed on 25/6/2011 and 19/3/2013. Then, my lord, bench clerk grade 2, my lord. They were promoted on 5/3/2012 and 1/9/2013 as against reserve quota for them. I passed and joined at 12/5/2015. Then, Lord, they admittedly they are being promoted as against reserve quota. Lord, here they were promoted on 3/11/2008 and 1/9/2020, and I was promoted on 30/6/2020. 22. Gradation list, my lord, of 2020, my lord, placed me at 107. 88, sorry. Serial number, they were placed on serial number 9. It is on 9.
Grade 1 है ये.
Clerk grade 1 है. OP3. OP4 continued below me. Then, not grade 1 bench clerk. This is 2023. I was placed in serial number 6. He was placed.
This is perhaps in challenge.
This is what is challenge.
We are in same there.
What is your statutory appeal order?
Huh?
What is the statutory appeal order?
There is a provision for
that is
annexure.
Annexure 6.
Annexure
6.
6.
No.
No, not
No.
Annexure 9.
Annexure 9.
Annexure 9.
Page 54.
Page
54. Has your lordship got it?
54.
You are hereby intimated that on consideration of your representation dated 19/7/2023, District Judge has been pleased to observe that you have claimed seniority in the gradation list above Sri Umesh Chandra Dalai on the basis of catch-up principle, whereas catch-up principle is not applicable in that case as resolved by the Department Promotion Committee, while Sri Umesh Chandra Dalai was promoted to post of bench clerk grade 2 on 29/2/2012, and you are promoted to the post of bench clerk grade 2 on 2/5/2015.
There is an appeal provision before the High Court Committee, not this. Against the order of this.
This is the representation.
There is an appeal committee, statutory appeal committee.
Statutory नुह था
अच्छी statutory appeal committee
examine टिके कर देवे
कर दियंतु देखि committee in high court
सेटा भी delay ही जो होने
नहीं 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 तारा
we cannot
it up
overcome it
just
that's even condone the delay and
हाँ नहीं नहीं अपन ये देखी दियो we can take up tomorrow there is
ओ ସେଇଟାରେ ଯୋଉ delay ହବ ସେଟା that ହଁ rightly sir examine कर दे
put up this matter tomorrow
next week
Ali if you also examine my brothers said that there is a statutory appeal committee of this court and this type of order can be taken care of by the appellate so Mr. Mahanti when it will be listed next week
any day that is convenient to
the petitioner has challenged
not on Monday
all right
Tuesday
the petitioner wants to challenge this order you just mentioned from the during course of argument after placing the comparison chart Mr. Mahanti 6 times next week to examine whether there is this order can be assailed before the statutory appeal committee of this court. Put up this matter. 12 तारीख से रखिवा? Put up this matter on 12th of November 2020. Comparison chart is taken on record.
My lord, I am listening for the opinion but see here. My counter is ready. I will solve the copy and file in the registry.
Necessary. I will file the
I'll file in the registry.
Counsel for the opposite party number 3. 4 point की appeal करना है?
ना
3 4 details in the private party. Correct. Mr. Amit Kumar Das and counsel appealing for the opposite party number 3 submits that the counter affidavit is ready and will file it by next.
In course of the in court, I solved the copy already.
During course of this week, serving a copy on the land council for the petition. Okay, put up this matter on 12th of November 2026. Yes.
Statutory
So rest of the matter tomorrow is tomorrow. I think.
List item number 2.
May I please, Your Lordship? My Lord, there is a mistake by us. There was no IA for bail. We undertake to file it by tomorrow. The petitioner is appellant is inside custody.
IA?
There is no IA for bail.
It has come because of that prisoner's petition.
Again.
Prisoner's petition. Final bicharo. How many appellants are there?
One appellant is
one appellant. 30/11/2017. 17, right? Class B out of how much you want?
24.
Class B at 20. Later. 24. All the class thing. Binombre का जैसे ऑर्डिनल सॉन्चो बुझासे ने कौन भी सरकारी वकील द्वारा मोर फाइनल
सरकारी वकील बाबू को द्वारा फाइनल विचार करा जाए He wants an engagement.
File this.
गलत नाम
Flag A receive करथिला मिस्टर डीपी राउंड करथिला तापर फ्लैग बी रे पहले आउ कोनसी कौन करो जो also filed बी नामा केबे करो
2020
एटा पूर्ण वकालत नामाटा ये बे गोटे पिटिशन देइची 2024 रे जे कौनसी सरकारी वकील द्वारा मोर विचार करा जाओ मोर तो आपण जदी ता पई थिले 2014 अपील 2017 रे फाइल करचंती
ଆମେ 2020 ରେ ଫାଇଲ କରିଛୁ वकालत
हाँ से बड़ी 2024 रे पुणी कोन पई हाईकोर्ट को रिक्वेस्ट करचंती जे कौनसी सरकारी वकील को जदी रे करा जाओ बोली maybe that he is not able to pay the fees etc. That is why he has requested associated jail criminal appeal. So
23/4/24 23/4/24 16/4/24 रे एटा ऊपर स्टाम्प ହେଇଛି ଗୋଟେ କେତେବେଳେ ऊपर ଗୋଟେ स्टाम्प ଆସିଛି 16/4/24 ସେଟା ଗୋଟେ ଜେଲ 14 ଏଇଟା 14/4 ଏଟା 14,000
এটা 16 एपी कार्ड
ଏଠି
এটা কোটি কার सर्कल जेल 14 अच्छा तो 50 तो लाओ ते सर्कल जेल 14 को ये कौन से लोकटा को कहबे जॉइन करियो है ना 14 सर्कल जेल को कोन तो ते अपेलेंट को आणि जॉइन करेगा ऑनलाइन में
जेसीआर ले 8/14
आइटम नंबर 2 next matter
Item 3.
May I please? Last occasion, Rashid has pleased to sought for an report, but
एक्चुअली कोई जो इसे सुनो से पैनल नुआई थी तो काम करो रजिस्टर कोई जो कम्युनिकेट कर जॉइन कर इतने देरी हो गया करो है ना इमीडिएटली को से जॉइन करो ये अच्छी ट्रांसफर जाई कर सपोर्ट जाई सपोर्ट भी जाओ यस आइटम नंबर 3
और item 2 or item 2
item number 2 you from your side also you try I'm sending the message we are sending the message to चौद्वार सर्कल जेल सुपरिटेंडेंट को कहबो ऑनलाइन ने ताकर अछि से सुशांत जो अपेलेंट ता ना दे देबे कहबे से एडवोकेट एंगेजमेंट संक्रांतियो पचरा कोन चिठी दिरा पिटिशन दे से विषय ना पचरा पचरी करबे ता कहबे से ऑनलाइन ले ते अपीयर करिवो will ask the that man directly whom you want to examine because it is a 2014 matter paperwork is ready Mr. DP Dhar senior advocate was appearing now he has written a letter that he wants to engage a government counsel means legal aid counsel for us so what is his problem we do not know so let him tell yes learn counsel
my lord, last occasion instruction was sought for.
What instruction was sought for?
Though it is a bail under section 3 CST, so I have sought instruction was received from Umarkot police station that the victim is interested to appear or not. Order number 9, my lord. Dated 21/10/2022.
So one of the offense for which you are found guilty
my lord
is under section 3(2)(b) of the SC/ST Act, right?
My lord.
So that is why it was directed to serve a notice on the informant.
I have already served, my lord.
No, you have served the
It
extra
was to be
copy.
confirmed from the Umarkot police station.
My lord, on 22nd 10 2024 we have already sent the letter, officer sent the letter. There is no instruction.
ଯୋଉଟା ଲେଟର ଆପଣ ପଠଉଛନ୍ତି ତା ଦେହରେ ଡେଟ୍ ଦିଆ ହେଇଛି ଏ ଅର୍ଡରଟା ପାସ୍ ହେଲା 1/10/2024 ରେ ବୁଝିଲେ ତାରିଖ ଧାର୍ଯ୍ୟ ହେଇଥିଲା 21/10/2024 ରେ ଆସିବା ପାଇଁ ତେଣୁ ଆପଣ ଚିଠି ପଠେଇବେ 22 ତାରିଖରେ 22 ରେ ପଠେଇଛନ୍ତି ତ 21/10/2024 ରେ ଆପଣଙ୍କ ସବମିଶନ कल पुणी जे submitted जो after receiving the extra copy of the appeal memo the same has been sent to so and so but he is yet to receive the confirmation letter तो 22/10 रे पठेले एपर्यंत confirmation letter आसीनी आईआईसी कोन रे जॉइन करियो हला वर्चुअल मोड रे उमर कोड हला पास ओवर कोन ठीक है वेट करो
Item 4.
Wait, please, my lords. Lords, here the appellant who was in custody since 26/2007 was by your lordships order dated 29/7/2024 was granted interim bail for a period of 1 month owing to his long custodial detention of 17 years. And after, my lords, he has surrendered, I have renewed my prayer for bail. And if your lordship will kindly see, by order dated 1/10/2024, my learned senior for the state was instructed to take instruction whether there has been any violation.
Yes, sir.
That particular we have not received the instruction.
No, when you sent that?
No, that file is not with me. So I pray tomorrow day after
tomorrow. On the request of the Land and Council for the state, list this matter on 6th of November 2024.
Grateful, my lords.
Item 5. May I please address?
How would I matter with 15 matter? Connected matters. Yes, JCRLA.
May I please address? In this matter, pursuant to the prisoner's petition dated 29/2022, I have filed the IF for premature release, your lordship. With respect to the Honorable Apex Court's order in...
Your appeal has been dismissed or what? The CRLA has been finally disposed of.
I don't know.
You do not forget, you do not understand. You have preferred an appeal against your conviction order passed by the Land and Additional Session Judge Jajpur
Yes,
under
sir.
section 302, right? You have been sentenced to life imprisonment.
Yes.
Your appeal is pending.
Yes, sir.
So you are to argue the appeal. Where is the question of premature release? You can apply for bail. Matter is different. So it is up to the appropriate government to consider.
Yes, sir. Pursuant to the Honorable Apex Court's order in... That is so moto writ petition criminal number 4 of 22.
Which paragraph?
That is at
Please
paragraph.
use the mic properly. Mic adjust.
That is the relevant paragraph is para 6.5, lordship.
6.5.
Yes, lordship. May I place, lordship?
Just the heading को आगे आसो तू.
आगे.
Our heading which is suggestions where the convicts are undergoing fixed terms of sentence and are in jail. Hello?
Aye.
In this behalf, the following suggestions have been made. Koda karibe?
Taro hoji 6.5.
6.5, yes.
Aye.
para 11 ର 6.5 clause ଟା. So if the accused is willing to accept the plea and make an application to the High Court, then the list of such accused should be forwarded to the Director General of Police to ascertain the criminal antecedent of the convict. Such plea bargaining at post-conviction level would not be available. Then there are some conditions, let's see. So
how this is to be applicable?
Yes, let's see. In that point, let's see another. Prior to that, let's say that is under trial review committee at para 5. Mr. Gaurav Agarwal points out that a considered data has been prepared of the under trials who were covered by the judgment of this court dated 24/4/2015 and 30/10/2017 in case of inhuman conditions in 1382 prisons. A timeline was laid down for the meeting of under trial review committees and implementation of recommendations of the said committee. A campaign for the release of prisoners by the under trial review committee to commemorate the 75th Independence Day in India by NALSA was also carried out. The total number of persons identified under trial recommended such and such. Out of the totals such and such under trials and in persons to campaign, such and such amount number has been released. The suggestions thus states that urgent steps should be taken so that at least 47,618 cases are dealt with. To facilitate the aforesaid, it has been prayed that all district legal service authorities may be directed to ensure that the bail applications in remaining cases are filed expeditiously in any event within 15 days, and the learned trial courts may be directed to.
That is for under trial prisoner.
Yeah.
Who are you? You are a convict.
I'm the.
It is not applicable to you. Under trial prisoners.
Yeah. But after that, you let's say. Where the para 6.5 that says.
Madam, this plea bargaining, is it applicable to a case under section 302 where life imprisonment has been? Have you studied this chapter?
Let's see, only the where it is not applicable, that was also reflected at para.
ଆପଣ ଯୋଉ paragraph ଟା ଦେଖେଇଲେ ପ୍ରଥମେ,
ଆଜ୍ଞା,
that is relates to a plea bargaining like case. Suppose you have been convicted and that offense comes within that plea bargaining
and for a fixed term.
And for a fixed term. But you said that yes, I am accepting that I may be held guilty. So that's so far as the sentence part is concerned, then that can be taken care of in that that is the provision.
So you read para 13. Para 13 is clear, not in
or remission of sentence.
That is not for these
convicts undergoing fixed term sentences. But also there is.
No, you read it. Read it. You read that paragraph.
7.1. There are convicts in jails who are undergoing fixed term sentences. In such cases where the convict has been sentenced up to 10 years imprisonment and is a first time offender and has undergone half the sentence, the state government can consider whether the remaining sentence can be commuted under section 432 CRPC as a one-time measure. The state government can obviously provide certain exceptions where this benefit would not be available to the convicts. So these are the exceptions. So the state government can impose conditions of good conduct.
Rape, dowry death, kidnapping, PC Act, POXO and
NDPS.
Those are exceptions.
These are the exceptions.
Then,
but here
it is
a murder
case. So
this is not.
Yes.
This is not reflected in this.
Not reflected. This is not coming on within the ambit of this.
So these are would not be available.
Are you having the book with you? Plea bargaining chapter, CRPC.
No, let's see.
To which cases it is applicable?
You see, the chapter plea bargaining shall apply so and so therein that an offense appears to have been committed by him other than an offense for which punishment for death or imprisonment for life or so and so has been prescribed. So in a case where life imprisonment is there, plea bargaining is not applicable. So where is the question of applicability of those decisions? So जो offense रे plea bargaining applicable habo, say restriction habo, that's a different matter. Here you have been sentenced to life imprisonment. Okay, apono jodi bail matter, that's a different matter. Bail is
and in case of life convict, where the matters are pending before the High Court, this is not the complete judgment. Come next, because the date was fixed subsequently. After that, you have not come. See the last paragraph. The cases of life convicts in jail whose appeals are pending before the High Court will be considered tomorrow. So what is the order thereafter?
That order is also...
Where is that? That you should read.
That is one copy. One day may be fixed. Let's see if I will come with that.
That you should see.
Yes, let's see. Only one.
Your matter is there only.
Only one copy is available with me.
IN number 101 of 2022. This is an application for premature release. This interim application has been filed with a prayer for premature release of the appellant in view of the decision rendered by the Honorable Supreme Court in the case of Seuta Juraj. So moto prayer reported in 2022 2022 SCC online SC 1487. However, after going through the decision placed, we find that in paragraph number 15 of the said order, it is mentioned that the cases of live convicts in jail whose appeals are pending before the High Court would be considered on the next day. The Land Counsel for the petitioner appellant submits and accordingly the case was directed to be listed on 15 September 2022. The Land Counsel for the appellant submits that for the live convicts in jail whose appeals are pending in the High Court, orders have been passed also by the Honorable Supreme Court so far as it relates to premature release is concerned, and he will place the decision of the Honorable Supreme Court. Kali rakhibe? Na,
Kali.
Tomorrow. I put up this matter on 5th of November 2024. So, have you given a copy to him? Yes. We'll find out first of all whether it is applicable or not. Section says it is not applicable. So, this appeals where the appeals are pending for life convicts, it was directed. We said that already order has been passed. Con order hechi dekhun, hala.
Item 6.
The item 6. There is a noting in the cause list. The IA has been 8/3 of 22 as for bail, but that copy is not available. Record.
No, with the counsel Ikta Agrawal, Shruti Modi, prisoner's petitioner for early hearing.
And 6 item 6.
6.
6.
Yeah. What do you want?
Here's a parts over. There is a noting in the IA 8/3 of 22 flag A for bail. But the IA copy is not available in record. That copy may kindly provided so that.
Where is the counsel for the?
My lord, I am appearing for.
So, have you dropped a copy?
My lord, I will drop a copy.
Even extra copy that is not there in their
My
file. IN number so on. So this is an application for bail. How many appellants are there?
My lord, in this case, one appellant.
One
appellant.
Land counsel.
Here is the case, sir. 6 appellants.
6 appellants. No,
Six.
he has filed the bail for
Not
all
one.
all of them, or
No, your-
And others. It has mentioned and others.
Means everyone.
no, he has filed for appellant number 3 as it appears
Appellant 3, Your Lordship.
IA number 83
Appellant number
3, Your Lordship.
3.
My lord.
This is an application for bail लिखिदेवे. Appellant number 3 Thodu alias Hiranya Mudali. Hello. Get a copy of the interim application be served on the Learning Council for the state and by tomorrow put up this matter next week. Yes.
Item 7.
Then for business fiction for early hearing. Paper book is not.
Wait. सरकारी वकील श्रीमती सुहांशु को अपील କରିଥିଲେ ଅଦ୍ୟାବଧି ବେଲ୍ का विचार ହୋଇପାରି ନାହିଁ ମାନ୍ୟବର ହାଇକୋର୍ଟ ମୋର ଫାଇନାଲ ବିଚାର କରିବାକୁ ଜଣାଉଛି ଅଧୀନା ଗରିବ ଶ୍ରେଣୀ ବ୍ୟକ୍ତି ଅଟେ ପୂର୍ବ ଓକିଲ ସରକାରଙ୍କୁ ଦିଆଯାଇଥିବା କ୍ଷମତା ପ୍ରଦାନ କରାଯିବ ଏବଂ because he wants to continue that
item 7
किए एडवोकेट जानते एकता अग्रवाल श्रुति मोदी
तो ଥିବେ ୟାଙ୍କର
SP senior advocate SP Mr. Associate ekta
मैडम कोन आସୁନାହାନ୍ତି कोन ପାଇଁ से 2015 ର ଏଟା पेपर बुक से रेडी है Peru the prisoner's petition at flag P stop non-appeals for the appellant in the prisoner's petition the appellant has paid for expeditious hearing of the jail criminal appeal. However, since paper book prepare paper book has not been prepared. The registries are due to prepare the paper book within this month and matter will be listed next month for hearing. Yes.
Item 8.
Filed an IA for bail, my lord. Appellant has been convicted under section 302 million and sentenced to undergo RI for life and pay a fine of ₹10,000. In custody, my lord, since 17/8/2015.
So documents which is
a copy of the IA not available.
ଆପଣ ପାଖରେ କଣ ଅଛି କହିଲେ
petition criminal appeal petition JCR
judgment ଅଛି
judgment only judgment only judgment
JCRL ଟା ଅଛି only judgment ठीक ଅଛି ते IA ର କପି ନାହିଁ
ନା IA ଦିଟା ଫାଇଲ ଗୋଟେ 190.224 for stay realization and IA 122.24
କପି ଦେଇଛନ୍ତି ବୋଲି ଆପଣ
ଦେଖଉଛନ୍ତି but this record is
ନାହିଁ ଫାଇଲ ସାମିଲ ହେଇନି କିଏ ରିସିଭ କରୁଛି କିଏ ସେଟା ବୁଝନ୍ତୁ ରିସିଭ କରି କଣ କରୁଛି ସେ ପୁରା କପି ଗୁଡା ଯୋଉ ଆଡଭୋକେଟ ମାନେ ଦଉଛନ୍ତି ତାଙ୍କୁ ଆପଣ ରିସିଭ ଦଉଛନ୍ତି ବସିକିନି ତାପରେ ସେଟା କନସର୍ନ ଫାଇଲରେ ସାମିଲ କରିବା କଥା ନା ନାହିଁ
next week I will call.
All right, so bail the Land Council for the state submits that there is no copy of the interim application in his file. However, the Land Council for the petitioner appellant has produced the receipt of the showing that the copy has already been served in the AG office. Put up this matter next week, that is on 11th November 2024. Yes.
Well, deposition copy to supply
in order to enable the state council to verify the availability of the interim application in the AG office. Deposition copies, you are serving it?
I'll serve today, man.
Deposition copy to be served, man. ये जो फाइल कथा कहउचंती आपनकर LCR judgment deposition जहाँ भी दरकार pen drive आने
that I verified that is available pen drive.
से आप कागज पत्र सोड़ा को धीरे धीरे भूली जाते हो. Yes, next.
Item 9.
Just two or three hundred files. Some jail penalty and
You use the mic properly. What
One
purpose it has come today?
two appeal has been filed. One jail
No, why it
penalty.
has come today in the list? It is for orders. Under the
Orders.
heading of orders, it has come. Paper book is ready, so it should have been in the list for hearing. Why it has come for orders? Have you filed any interim application for bail or anything like that?
No, it has not
Just
filed.
why it has come?
My lord, JCRL 116/18. This one appointed me to argue the matter. Thereafter, the legal aid also appointed my friend to argue the matter. He has filed CRLA. So one appellant, two appeals. I have not received the paper book.
No. Once the regular appeal is filed, so the jail criminal appeal would not be, that would be disposed of because he has filed the jail criminal regular appeal. So is a single appellant.
Single appellant.
Yes. Sir, not removed, but in the meantime, delay has been known. Case has been admitted. Paperwork has also. It on the upper JCRLA number 116 of 2018. It appears that the appellant has already preferred criminal appeal number 395 of 2019 against the same impugned judgment and order of conviction. And therefore, this JCRLA is disposed of. Further disposed of further. Second CRLA number 395 of 2019. Let's say second of 395.
90.
What is this IA? There is an IA limitation at all. Delay convention. That IA has been disposed of or not? No, disposed of delay condonation. Since
Delay condonation.
You have received the paper book.
Yes, sir.
And you have also received the paper. To get ready for hearing, paper book has already been prepared. The matter be added to the hearing list in the first week from December 2024. Yeah.
Okay.
Item 10.
In May stage alert. But I am sorry because I'm serving
File ଅଛି ନଥିଲେ ଏଠି ଅଛି ଆପଣଙ୍କର ୱାକମ ରେ ଦେଖନ୍ତୁ
478 to 21.
So
I'm serving the disposition copy, my lord. Petition the appellant was I did it. I like it.
What is the conviction here?
At 302 imprisonment for life, my lord. And you this one court has also granted interim bail for the death of the father of the appellant for 3 weeks. He has my lord released on bail and also surrender in time without violating any terms and conditions, my lord.
So now you have filed the application for bail on merit.
Bail, my lord.
Earlier, your bail application was never rejected on merit.
No, not that is pending.
Okay.
And a custody certificate more than custody from
order dated 17/3/2023.
17/3/2023.
pending.
That was IA number 620 of 23 that has been disposed of. Yes. That was a prayer for interim bail.
Yes.
So now it is for a regular bail, that is 478 of 2021. So, by the way, what is your period of detention?
Period of detention, my lord. Custody from my lord.
Where is the custody certificate?
Custody certificate.
It is not.
22/12/2015
Custody certificate not there. 22/12/2015.
Yes, my lord.
And you have served the deposition copy.
Yes, my lord. I have
Not
served.
sure by
All right. The Learned Counsel for the appellant submits that the appellant is in judicial custody since 22/12/2015. Stop. He has also supplied the deposition copies of all the witnesses examined in the trial court to the Learned Counsel for the state, who seeks some time to produce the custody certificate. So, who jail katha koi diun?
My lord, Berhampur, my lord.
Holy Court पर है ना? Sessions judge Holy Court पर पड़े तो हाँ, let them have it.
Panjam Berhampur, my lord.
ଯେତେବେଳେ ଏଇ ଟାଇପ ର ଅର୍ଡର ହବ ତାଙ୍କଠୁ ନେଇଯାଆନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ କୋଉ ଜେଲରେ ଅଛି that would be better ହେଲା custody certificate. So it will be, you just send it by tomorrow. If you can get it during the course of this week, it can be taken on next week or a week after. Let it come on 18th November. All right.
copy of 3 copy.
Which copy? Not necessary. All these are uploaded, so you can
Public.
Okay.
Item 11.
The party.
May it please your lordship. In custody since 29/10/11, 302/34 and also Arms Act.
এটা আপনার matter?
Right.
আচ্ছা
Sole
20 sole appellant only.
अच्छा.
In custody since 29/10/11.
Just a minute. 29/10/2011. Yes.
302/34.
Have you ever been released on bail?
1 month, your lordship have granted.
1 month.
My lord, by order dated 37/24.
37/24 ଏବେ
ଆଜ୍ଞା
କଣ ପାଇଁ ଯାଇଥିଲ ମାସେ?
ନା ଆପଣ interim bail ଦେଇଥିଲେ.
interim bail ଦିଆ ହେଇଛି. Has he surrendered?
Surrender. He has surrendered. Surrender certificate has been submitted. Your lordship had directed the state council to take instruction whether he took liberty or not, took misuse of liberty or not.
All right.
So, where is your surrender certificate?
Surrender is there, submitted along with the petition. IA.
Along with the IA.
My lord.
The present IA is 2646.
2646, my lord.
24, and the surrender certificate you have filed.
My lord.
Okay, so what instruction you have obtained that what was his conduct during that period of 1 month of interim bail that you are supposed to obtain from the concerned police station, that is IIC of Gopalpur police station. Yes. Ashwini, what region there? Have you sought for an instruction from the IIC of Gopalpur police station? Are you having the copy of that order dated 37/24? 30/7/2024 ର ଏଇ ଅର୍ଡର ଗୁଡା ସବୁ ଆପଣ ଆଦିରୁ ପାଇଯିବେ। ସେଇ ଦେଖିଦେବେ 30/7/2024 ରେ ଆପଣଙ୍କୁ ଗୋଟେ ଅର୍ଡର କରାଯାଇଥିଲା ଇଏ ମାସକ ପାଇଁ ଆକୁ ଆମେ ଯୋଉ ବେଲ ଦେଲୁ ଇଣ୍ଟ୍ରିମ୍ ବେଲ ୟାର କଣ୍ଡକ୍ଟ ବିଷୟରେ ଗୋଟେ ରିପୋର୍ଟ ଆପଣ ପ୍ରଡ୍ୟୁସ କରିବାର ଥିଲା ତ ସେଇଟାକୁ ପ୍ରଡ୍ୟୁସ କରନ୍ତୁ ହେଲା। IA number 2646 of 2024. This is an application for bail. Learned Counsel for the petitioner, Mr. Pujari, submits that after availing the interim bail period, as per the order dated 30/7/2024, the petitioner has already surrendered in the trial court and he has annexed the surrender certificate to the interim application. Though, as per the said order, the Land Council for the state was asked to obtain the report from the IIC Gopalpur police station regarding the conduct of the petitioner while on interim bail, but the same has not yet been obtained. Land Council for the state seeks some time to obtain the same, put up this matter on 18th November 2024. This order would be uploaded today, maximum by tomorrow. So accordingly, you take the instruction. Okay.
Item 12.
Mr. Jafrullah. Okay. Password.
Item 13.
Here is also there are 1, 2, 3, 4. 4 appeals are there. 4, no, 5. 5 appeals are there, and in all the appeals, interim application has been filed for bail. And previous order was passed that you are to not only produce the custody certificate from the concerned jail superintendent, but also instruction regarding the conduct of the petitioner during the interim bail period. So any communication has been made by the previous state council in that respect to the jail superintendent or to the concerned police station?
Minor in criminal appeal 178 of 22, interim bail for 2 months was granted and social behavior certificate was called for students.
आनिले कि नाही से रिपोर्ट the problem is that they have joined today, so
instruction ଆସିଛି.
Is it available?
IAC Saranpur police station ro.
Don't know whether it is Saranpur or anything else. But if have you obtained the report or the letter has been sent, he has not responded. এই order অনুযায়ী দিটা ଆପଣଙ୍କୁ instruction ଗୋଟେ ହଉଛି custody certificate ଆସିବ superintendent jail superintendent ଆଉ ଗୋଟେ just a minute wait ଆଉ ଗୋଟେ ଆସିବ
conduct
certificate तो ये दिटा को obtain चिट्ठी ଯଦି ଲେଖା ହେଇନି ଆଉ ଯଦି ଲେଖା ହେଇଛି ତାହେଲେ obtain କରନ୍ତୁ ହେଲା ଲେଖନ୍ତୁ
another small problem criminal antecedent of the
the Land Council for the ଗୋଟେ matter ଲେଖିଦେବେ ସେଇଭଳି ସବୁ ଗୁଡାକରେ ମଗେଇଦେବେ ଆଚ୍ଛା ଯୋଉ କେସରେ interim bail ନଥିବ ଲେଖିବା ଦରକାର ନାହିଁ ଯୋଉ କେସରେ ଥିବ ହେଲା ଯୋଉ କେସରେ ଥିବ ତାକୁ ଲେଖିଦେବେ Land Council for the state take some time to produce the custody certificates also regarding certificate regarding the conduct of the petitioner while on interim bail. जो थे interim bail नथिबे खाली लिखिबे custody certificate तो दीटा कैटेगरी रहो जो थे bail थिबे ताको ए दीटा कोड जो थे bail नथिबे खाली custody certificate हला हम दिखाउता तो एगुडा को सब तक आसीबो 18 तारिख को 23 दिन so this is the जो थे bail थिबे order on जाई ସେଥିରେ ଆପଣ ଆଣିବେ ଦିଟା ଜିନିଷ custody certificate ଆଣିବେ jail superintendent ଆଉ ତାର conduct କଣ ସେଇ ଯୋଉ period ରେ ସେଟା ଆଣିବେ IAC ହେଲା ଯୋଉଟାରେ bail ନଥିବେ totally bail ଦିଆ ହେଇନି interim bail ଆଗରୁ ସେଥିରେ କେବଳ custody certificate ହେଲା ଏତିକି ଆଣିବେ
has already been submitted
କୋଉଟା
ଏଇ social behavior certificate and custody period. Report was called for earlier and it was submitted on the last occasion.
नहीं तो अपन कितना नंबर मैटर
231
231 as well as 178 ए दुईटा जाकर इंटरिम बेल थिला एथरे आसी जायथला
custodial
custody certificate आथला as well as the social behavior certificate
231 रो ऑर्डर होची लास्ट ऑर्डर 31 नंबर
231 178
हां लास्ट ऑर्डर इज
no, that is surrender certificate has
79 2024 that's 31
178 and 231
IA number 473 of 2022 रे order ହେଇଛି Land and Council for the state seeks some time to produce the obtain the custody certificate from the concerned jail superintendent and obtain instruction regarding the conduct of the petitioner during the interim bail period. That was the last order. तापर तो किसी order ହେଇନି ଆପଣଙ୍କୁ କଣ ପାଇଲେ ଏଇଟା ହଉଛି last order 17/9/2024 ପରେ ଆଉ ଏ matter ଆସିଥିଲା କି that is the last order. Court पाइले आनी की दे देलेनी हम yes छानो दासु से 18/11/2020
name maybe
John consent and change like the CRL number 215 of 2022 Mr. C.DASH and counsel has filed the consent memo for appearing the appellant with the no objection from the earlier engaged counsel. The consent memo is taken on record. The name of Mr. C.DASH shall be reflected in the post list and the two matters that on the court
the flag A flag B जो item 2
item judgmental
item 2
instruction किए दिला रही
ये तो नहीं
बड़े वाले से की
Southwell Circle Jail. Southwell Circle Jail की ऑप्शन थी सर
आगे से सुशांत ओरफ सुशील कुमार साहू
आगे सर
से अच्छे की पाखरे
सर
डाकी दियंतु डाकी देला परे आपण कोन अछंदी
वाटर अछि
अच्छा सुपरिटेंडेंट कोड गले
सर सी एटा सारा बीसी हमने चलिछि ऑफिस स्टेशन अछि बिगड़ अछि
से सुशांत अलियास सुशील कुमार साहू ये जाकू जिला जज जाजपुर रे से आजीवन कारादंड दिया इतला ताकू डाकी आनंतु आणला परे कनेक्शन हबो हमें कथा वार्ता हबो ता से हला
आज्ञा सर
Next matter.
Item number 13.
So there is a direction last occasion to take instruction about the health condition of the mother of the appellant. I filed an interim bail for that.
ପଠେଇଲେ କି ଚିଠି ପଠେଇଥିଲେ ଆପଣ ଚିଠି ଗୁଡାକ ତଳେ ରହେ ନା ଉପରେ ରହେ ସେ ଫାଇଲ ଯୋଉ ସିରିୟଲି କରିକି ଯୋଉ ନିଅନ୍ତି ଏକ 7/10/2024 ରେ ଗୋଟେ ଅର୍ଡର ହେଇଥିଲା ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ଦେଇଥିଲେ ତାଙ୍କର ମାଙ୍କ ଦେହ ପାଇଁ ଚିକିତ୍ସା ପାଇଁ ତାଙ୍କର ଦରକାର ହଉଛି ପ୍ରେଜେଣ୍ଟ ସେଇଥିପାଇଁ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ରେ ଯିବା ପାଇଁ ତେଣୁ ସେଇ ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ଉପରେ ଆପଣଙ୍କୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନବାକୁ ଡାଇରେକ୍ସନ ହେଇଥିଲା ସେଇଟା ହଉଛି 23/5/2024 ତେଣୁ କେତେ ଗୁଡାକ ମେଡିକାଲ ଡକୁମେଣ୍ଟ ମଧ୍ୟ ସେ ଦାଖଲ କରିଛନ୍ତି ସେ ମେଡିକାଲ ଡକୁମେଣ୍ଟ ଗୁଡାକ ଜେନୁଇନ କି ନାହିଁ ହେଲା ଏସବୁ ବିଷୟ ଆପଣ ତ ଚିଠି କିଛି ଲେଖା ହେଇଛି କିଛି
4/11/24 ଲେଖା ହେଇଛି।
ଚିଠି କିଛି ହଉ ସେ ଇମିଡିଏଟଲି କନସର୍ନ ପୋଲିସ ଷ୍ଟେସନ ଯୋଉଟା କି ହଉଛି ଏଇ କେସ ରେ କୋଉ ଥାନା କେସ୍ ବାଲେଶ୍ୱର ଟାଉନ ପୋଲିସ ଷ୍ଟେସନ ବାଲେଶ୍ୱର ଟାଉନ ପୋଲିସ ଷ୍ଟେସନ କୁ ପଠାନ୍ତୁ ସେମାନେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ହେଲା ଦେଖନ୍ତୁ ଆଇଏନ ନମ୍ବର 305 of 2024 as per the order dated 7/10/2024 so the Land Council for the state was asked to obtain instruction on this interim application which was filed for interim bail on the ground of mother's ailment. Land Council for the state is yet to receive the instruction and 6 for an adjournment. Put up this matter in the week commencing from 18th of November 2024. Instruction be obtained in the meantime, including the authenticity of the medical documents which are annexed to the interim application. Hello? So, 18 तारीख आसीबो से मेडिकल डॉक्यूमेंट जेन्युइन कि नाही बाकी तार मां को देह विषय रे जहां लिखाई छै आनी विषय इंस्ट्रक्शन 18/11/2024. You comply the order because once you leave the file as such and you will say that we will do it tomorrow, tomorrow's work will be overburdened by ଆଜିର କାମ ଜାଣିଦେଲେ ଅର୍ଡର ଏଇଆ ପାସ୍ ହେଇଛି ବୋଲି ଯଦି କିଛି ଅର୍ଡର ଡାଉଟ ହେଲା ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ହଉଛି ତାକୁ ମଧ୍ୟ ଆପଣ ଦେଖିପାରିବେ ଦେଖିକିନି ଏଇଆ ଅର୍ଡର ହେଇଛି ଆକର୍ଡିଂଲି ଇମିଡିଏଟଲି ଆଜି ହିଁ ଇନଷ୍ଟ୍ରକ୍ସନ ସବୁ ପଠେଇ ଦିଅନ୍ତୁ ହେଲା ହଁ ୟେସ୍ ନେକ୍ସଟ
Item 15.
May I please? Last occasion custody certificates are sought for. Custody certificate and criminal antecedent.
Criminal antecedent तो नहीं बोली असला खाली अच्छा प्रोड्यूस कस्टडी सर्टिफिकेट तो होला both the documents are taken on record अछि आउ तो किछ डॉक्यूमेंट दरकार नहीं you have to place the matter
My lord, I have filed an IM.
17/24 रे ऑर्डर ହେଇଛି जे कस्टडी सर्टिफिकेट रिसीव करा जाईछि
My lord,
आ बाकी मालकानगिरी मॉडल पुलिस स्टेशन रु रिपोर्ट आछि जोथरे जणा पड़छि आपन नारे किछि क्रिमिनल एंटीसीडेंट नाही तो आपण
My lord.
आर्गुमेंट करिवे ना एडजर्नमेंट नेबे
my lord, no, argument. My
हां
lord, argument for my lord.
आर्गुमेंट करिवे
I have filed an IA, my lord, for interim bail, my lord. Is custody from 24/5/2017.
24/5/2017
My lord, for commencing.
बेल रिजेक्ट ହେଇଛି କି मेरिट रे
No, my lord, this is first time.
first time so you have been found guilty under what offense
under section 302 only, and two other offences already acquitted, which are 201 IPC and 12 of POCSO Act has been acquitted.
So 302A, what is the allegation against you? You come to the second paragraph of the impugned judgment.
My lord.
ଆପଣ ଏଇଟାকে ୟୁଜ କରୁନାହାନ୍ତି ୱାକମ୍ ଡାଇସି ଅଛି ଏ ଜଜମେଣ୍ଟ ବାହାର କଲେ ଜଜମେଣ୍ଟ ର ସେକେଣ୍ଡ ପେଜ କୁ ଯାଆନ୍ତୁ ଏଇ ୱାକମ୍ ୟୁଜ କରିବାକୁ ଗଲେ ଯିଏ ଆର୍ଗୁଇଂ କାଉନସିଲ ସିଏ ରହିବ ସେଠି ମିଷ୍ଟର ନାୟକ ଆପଣ ପଛକୁ ପଳେଇ ଯାଆନ୍ତୁ ଦେଖ ବାହାରିଲା ଜଜମେଣ୍ଟ ବାହାରିଲା So now you come to the second page, paragraph number 2. The mic on ଅଛି paragraph 2 ଟା ପଢନ୍ତୁ ଆପଣ
In 13, the informant of Vera, wife of Arjun Vera.
କୋଉ କେସ ର ପଢୁଛନ୍ତି paragraph 2 of the impugned judgment.
Case of the prosecution.
This is item number 15. JCRLN number 110 of 2022. Judgment has been pronounced by the additional session judge, special judge Malkangiri. Two.
On 19/3/17 at about 7.
Right. That is central. Please come to the front.
7 a.m. The daughter of the complainant had gone to the nearby jungle to collect mohua flowers. While she was collecting mohua flowers, the accused was dragging his daughter to the jungle, which was seen by one Nanda Markami of the same village. Nanda Markami informed the matter to the parents of the victim, so the complainant of the victim girl, along with others, searched her in the nearby jungle area but could not find her. While the complainant and his wife were searching the victim on 23/2017 at about 3 p.m., the victim was found dead in the nearby jungle of the village Katmatman. Having been aggrieved, the complainant reported the matter Malkanagiri PS basing on the report ISC Malkanagiri PS registered Malkanagiri PS case number 57 of 2017 and directed SI of the police named Sukanta Kishore Pradhan to take up investigation. During investigation, SI of police Sukanta Kishore Pradhan examined the complainant, conducted inquest over the dead body and prepared inquest report. Sent the dead body for postmortem. Visited the post, prepared spot map, seized the command certificate and wearing appearance of the deceased.
Okay, now you come to paragraph number 15, page 9. This is the doctor who conducted PM examination. Did you get it? That page?
PW 12.
15. Page number, internal page is 9, paragraph number 15. Okay, so this is the report and see the finding on the next page, page number 10. Read it out. As the body
was in a state of decomposition, the specific cause of death could not be ascertained. People took kept a viscera of the deceased from chemical examination on 5/6/2017 and the inquiry from him. As to the cause of death of the deceased, he replied that as the body was received in a state of advanced decomposition, no external injury was detected in the body, but the possibility of death by strangulation cannot be ruled out.
Now you come to the next paragraph, paragraph 16. Just read the first paragraph.
From the evidence available on record, it is appeared that the case is based on purely circumstantial evidence, as there is no eyewitness.
So there is no
to the crime.
Eyewitness to the occurrence. Case is based on circumstantial evidence.
Right.
Now he has discussed the evidence, the principle of appreciation of the circumstantial evidence in paragraph number 18, right? Now you come to the paragraph number 19. Page number 14.
In the presented, the deceased was last seen with the accused by period 6 and thereafter she was found dead. Hence, in my opinion, it is the accused who
You see the analysis, decisions quoted, no discussion, just last seen by PW6. So just find out the evidence of PW6H, PW6 evidence. So practically no discussion and life conviction. So this is the way
last seen, that is how life.
So heard the learned counsel for the petitioner, learned counsel for the state, the learned counsel for the petitioner submits that the petitioner is in judicial custody since 24/5/2017.
The residual section with age discussion.
He submits that the occurrence in question took place on 19/3/2017 and the case is based on circumstantial evidence, which would be evident from paragraph number 16 of the interim judgment. He further submits that the doctor bracket PW12 who conducted post-mortem examination has specifically stated that as the body was in a state of decomposition, the specific cause of death could not be ascertained. However, he submits the doctor stated that since no external injury was detected in the body, but possibility of death by strangulation cannot be ruled out. And accordingly, without discussing the evidence on record, the learned trial court has jumped to the conclusion that since the deceased was last seen with the petitioner and the thereafter she was found dead, therefore the appellant, therefore the petitioner had committed the murder of the deceased by strangulation. The land council further submits that there are good chances of success in the appeal and balance of convenience in his favor, and therefore the said application may be favorably considered. Land council for the state opposed the prayer for bail and placed the relevant part of the judgment, so also the evidence of the doctor PW12 and the evidence of PW6 who stated about the last scene. So considering the submission made by the land council for the respective parties, nature of evidence adduced during trial, absence of any direct evidence, nature of circumstantial evidence, period of detention of the appellant in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Obligats.
So, see, there are death reference cases 1, 2, 3, 4, 5, 6 different death reference cases are there. So, you better take instruction from the learning AG as to whether he wants to argue these matters himself or he wants to entrust it to someone for argument.
Consistency should be maintained.
So, ordinarily in death reference matter, the precedents where the AG used to argue, otherwise the government advocate used to argue. If that is not possible, then he has to entrust it to some advocate, and advance preparation is necessary. We cannot treat it like other criminal appeals. Okay.
I would like to order the policy 5/2024. This case, Mr. Devashish Pandal and counsel appearing for the appellant submit that he has instruction that the appellant has been acquitted in the said case after facing trial in the Court of Assistant Session Judge Special Court Baripada in Sessions 12 case number so and so as per this. Led learned counsel to for the state verify the said aspect. The petition has the accused has one criminal antecedent that is in the record measure. That is in IA. That judgment copy is available in the record.
No, that's all right. It's all right. What that is during, you see, when the matter was placed, so on sentence point, perhaps there was something, and you brought out that he has a conviction, and he said that he has already been acquitted. So that is for different reason. Now it is to be hard phrase, right? So that is why we are asking you that you take concrete information that who is to argue the matter. And once a counsel is engaged to argue a death reference matter, he should not be changed. He may be posted in any other court, matter is different. But once this matter is taken up, he has to remain present. Because he must have prepared in that way. So it's not like other matters that you change the counsel every day, right? So obtain the instruction from the learned advocate general and state all these matters, 5 to 6 matters are there.
16 to 21.
All right. Now so far as the jail criminal appeals are there, who is the counsel who is ready in this matter? Item number 1, right?
1.
Item 1.
That's the issue.
Pochan.
Circle the chowk ଆସିଲେଣି?
ऑन करी गोटे साइड रखी देता जो मोमेंट आसीओ कहबो टेकअप कर केनल पुनी आसी अपेक्षा करथिबो जेतो Yes, Ms. Tripathi. So you argued this matter.
Only the judgment was to be given.
You we put a question to you. Just. बाहर करो सफाई जजमेंट भर के आपनकर ना सुशांत ओरफ सुशील कुमार साहू बापांक ना होची बिपिन साहू गाँ होची आपनकर ठाकुर पाटना जाजपुर जिला हरि रामचंद्रपुर थाना अच्छा आपण जो जिला जज कोर्ट रे विचार सम्मुखीन होइथिले एवं आपण को जिला जज 6/1/2014 आपको 302 दफा आजीवन कारादंड आदेश देते एवं अन्यान्य देते आपण जो अपील टी प्रिफर करते जेल रू Yes, Ms. Tripathi,
Yes, Your Lordship.
when you argued this matter,
Yes, Your Lordship.
we put a pertinent question to you that apart from the evidence of your own family members, that you are very much present in that room.
Not in that room, Your Lordship. It was in the other room he was present.
No.
Last scene it was there that he was.
You are present in that room when earlier, but when they heard the cry and came to that room, they found the dead body with injuries, and you were in another room,
Yes, Your
right?
Lordship. Yes, Your Lordship.
And you have confessed that in question number 9 and question number 14,
Yes,
in
sir.
your 313 statement, you have admitted that question number 9, it is put to you, that is page number 27 of the paper, that it reveals from the evidence of PW9 that you murdered your wife by means of Hanso Kola, which was seized by the police. What have you got to say? The answer has been given.
ସ୍ତ୍ରୀକୁ ହଂସ କଳାରେ ବାଡେଇ ତାକୁ ମାରିଦେବି.
Again, in the last question, that is question number 14 ମଧ୍ୟ ଆପଣ କହିଲେ ଯେ ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ନିଜେ ମର୍ଡର କରିଛି. Now, if you come to the evidence of PW2, PW2 is your father, and what he stated, apart from the dispute, that one line in paragraph number 1, that is last line, before death, my son and daughter-in-law, means the deceased, right?
Yes, sir.
Were together in their room, which I had seen. This is most important. Now you read paragraph number 2.
And just prior to that line, on that date of death of the daughter-in-law, she was hale and happy as well as active. So there was no dispute. That shows, Your Lordship.
All right. Now you come to that. What paragraph number 2?
Yes, for sure. My daughter-in-law raised cry in a loud voice calling Malo Morigali, and hearing such cry, we went to her room. And after entering into her room, myself and others, those others were not examined, Your Lordship, found that she had received stab blows of knife on her body near the root of the ear and back with bleeding, and the spot where the dead body was lying were stained with full blood. At that time, my son was inside in another room of that house by closing the room inside.
Yeah. Okay.
I took the seized root in my Zimma, and Zimma is my signature.
So this others means this occurrence took place inside the house. So others means maybe it is the other family members. It is not the outside.
Outsider. It is mentioned in the PW statement of the mother of the deceased, Your Lordship, accused. She has stated that who all had been come.
PW?
PW Justice.
PW
12.
PW
12, Your Lordship.
Okay, what she has stated, let us see.
Page 52.
PW 12, you come to page 52.
Yes, Your Lordship. Particularly, I'm placing on PW 50, page 53, Your Lordship.
No, you come read that page
Okay.
52.
The accused is my son. The deceased is my daughter-in-law. I am residing separately with my husband. Accused and the deceased were staying in a separate room. About 1 year back, heard a sound in a loud voice calling Malu Morigali, and hearing such cry, we went to their house and found the deceased dead. I do not know how she died.
Right.
At this stage, she was turned hostile, Your Lordship. Then in para 3, it is not a fact that I had stated before police that accused Bonsidhar and the deceased Manika was blessed with 2 sons, and the accused sold away his tractor, and that went on eating the sale proceed of the tractor, and that thereafter out of poverty he quarreled with Manika, and on the date of incident the accused closed the door from inside, and that while his wife Manika was asleep, he by means of pointed rod stabbed at her body, causing profuse bleeding, injuries, and that hearing her screaming cry, Kulamani Sahu, Braja Sahu, and Abhay Sahu broke open the door and found the deceased on a pool of blood, to whom they shifted to the hospital in an auto rickshaw, where she was declared and dead, and the police reached at the hospital, and in our presence police conducted inquest over the dead body of the deceased, and I put my signature.
What
So
is your submission?
That is the
this.
submission.
This was the previous statement given to the police.
So the other person here
No,
is
and that
particularly
also she denied. That
denied.
also she denied.
That is exactly.
So how can we read it?
How we can take into account this
I'm saying
161
the
is a
mentioning of the
substantive
case
evidence.
present.
No, but that cannot be taken. No?
Cannot be taken as a substantive piece of evidence. Whether you have brought out anything from the evidence of any witness that apart from the family members, any other persons were present at the time of occurrence.
This you could have brought in the cross-examination now.
Yes, Your Lordship, that's what he is saying.
That has not been done.
And suppose they came afterwards, but by that time the occurrence is already over. So they become the post-occurrence witnesses.
One of the witness, Sahoo, he has been examined who turned hostile, Your Lordship. That is PW 11.
Yes, exactly.
Now the actual commission of murder nobody has seen.
Nobody has.
But the most important thing is that your presence with the deceased in that very room just prior to the occurrence. Then within few moments a sound is coming or the cry of the deceased. Then the family members rushed to that place or that room. They were found. They found that the deceased was lying dead. Blood was there. The accused was not there in that room. He has
Locked himself in another.
So it was ordinarily expected you to be there. If your case is that yes, no, not you, but somebody else from your family has committed this, not the outsider. Somebody, let us say somebody else has committed. So nothing is there on record.
Whether Chodar man is there, ask him to go. Let him go.
Pass instruction for no contact. तो डेट फिक्स रहेगा ये कौन था ना
सुशील
सुशील आपण
काइंडली अनम्यूट
आपण आउ किछ कहबे की अरे अनम्यूट करो से की से अछंदी जेल ऑफिसर की अछंदी की
हां हां कोन को
तांपरा तारीख धार्जल आउ कोन से कहबा चाहउचंदी
आज्ञा
आउ किछ कहबा चाहउचंदी
नाही आज्ञा
हाँ नाई नाई आपण जानतु आपण 18 तारीख रे तो सुनानी हबो आउ हला हां आपण जान हां
चलो
So it is expected by on behalf of the appellant being the husband that as other reacted, his reaction should be similar or more important. He should have immediately rushed to the spot to
show also that he was meant
rather he put himself inside a room and closed it. So it is just reverse.
It's one thing, 16 stab injuries are there.
Yes.
So maybe not for the last injury they heard the voice. Maybe in the
Correct.
first injury they might have heard and they might have rushed. But no one stopped him.
Now, who is the doctor?
PW
13.
13 year lordship.
Yeah, one penetrated.
How many total number of injuries?
16 year lordship. That has not been mentioned in this.
No, नहीं ठीक अच्छी but से 1 को गणी देले भी 2 3 4 5 6
It has been described in the judgment, your lordship.
7 2 9 10 12 अरे बाप रे पूरा इंजरी multiple lacerated wound, stab wounds, and apart from that this admission in the so what decision you brought?
This is of Allahabad High Court, your lordship. I refer to page 7.
Which is the paragraph relevant?
Para 30, page 7.
Paragraph 30.
30, your lordship.
Yeah.
In Sharad Viridchand Sharda versus State of Maharashtra, the apex court laid.
Leave it. Then
next.
Then and one is your lordship at page 13, para 61. That is regarding the 313 statement of nursing.
Which one? Paragraph?
61, your lordship. 61.
Just a minute.
Page 13. Reliance has been placed upon nursing versus State of Haryana, Supreme Court 496, where it is held that there are two kinds of examination under section 313 of CRPC. I'm coming to the relevant portion, the next paragraph.
Section 313 CRPC prescribes a procedural safeguard for an accused, giving him an opportunity to explain the facts and circumstances appearing against him in the evidence, and this opportunity is valuable from the standpoint of the accused. The object of 313(1)(b) CRPC is to bring the substance of accusation to the accused, to enable the accused to explain each and every circumstances appearing in the evidence against him. The provision of these sections are mandatory and cast a duty on the court to afford an opportunity to the accused to explain each and every circumstances and incriminating evidence against him. The examination of accused under section 313(1)(b) CRPC is not a mere formality. Then the next
So
page.
that is the general thing. So in this case, how far this case, once you have admitted, what has been stated there?
Your Lordship may come to the 313 statement. Your Lordship.
That you have stated that
In every question here, there is a denial, Your Lordship.
No, that's not denied. Correction denied.
Sir, only 9 and 14, Your Lordship, but prior to those questions.
So other
So
things
what
you
does
have
it
denied.
justify if you deny also?
Okay, there was a motive has to be established, Your Lordship. What is the motive? After 12 years, I'm hitting my wife so brutally. The motive has to be established. Not because dowry I demanded 12 years back, that I'll take a...
No, that is how it is specifically said that you have these special means of knowledge, being the husband present in the place scene of occurrence. So it was incumbent upon you to explain.
So maybe I may be shocked. I'm just visualizing. Maybe he was shocked. He couldn't explain. Other than that,
if you fail to shift your burden of proof, okay,
yes, sir.
then that is to be utilized against you. You are with your wife just few minutes prior to the when she was found dead. So and she was found in this state. Except your family members at that place, nobody was there. Those are all stab wounds and lacerated wounds. So who committed the murder and how your wife died, and particularly your reaction that you are not telling the name. Yes, XYZ have committed the offense and they fled away. You are not trying to rather rescue your wife. You are going and locking yourself in another room. So not explaining all this.
Not even giving a circumstance by which there could be some kind of inference that other than he could be the.
Unfortunately, the cross has not been done.
So that is exactly so cannot. But hard ଆପଣ କଣ କହିବେ ମିଷ୍ଟର ଏଇଟା କାଉନସିଲ ଚେଞ୍ଜ ହେଇଗଲା ଆପଣ ଆଚ୍ଛା ଏଇଟା ଯଥେଷ୍ଟ ନାୟକ ନା Yes, Mr. Nayak, what do you say?
That is the evidence of his mother and his father, activity of the mother and father.
What mother has stated? Nothing against the appellant?
Widow 12 Millard.
Yes, has he stated anything against his son, against her son? That his son has committed the murder.
No, they are saying that Marlo Morigali. He does.
That is stated, she has stated. But as she stated that the
sound is loud voice calling Marlo Morigali. The mother is staying in the side room of the accused. And hearing the such cry, we went to their house and found the deceased dead. I do not know how she died.
How her evidence is relevant so far as the appellant's complicity is concerned. He had this Marlo Marigali. She went to the house found the deceased dead. All these things are there, and they were staying together. So how this evidence of PW12 is relevant so far as this appellant is concerned? Appellant, it's a case under section 302 IPC. So you are to prove that the appellant is the author of the crime. So by this evidence, you say that how it is relevant. So who else were the staying in that house? The ଘରେ କିଏ କିଏ ସବୁ ରହୁଥିଲେ? Accused ରହୁଥିଲା,
the wife
accused ରହୁଥିଲା,
and his
then
father and mother
PW2 ରହୁଥିଲେ,
and PW12
PW12 ରହୁଥିଲେ, ଆଉ କିଏ ରହୁଥିଲେ?
ଆଉ ଜଣେ ଭାଇ ଯେ ସେ ଅଲଗା ରହୁଥିଲେ।
ଆଚ୍ଛା, ଏତିକି ଲୋକ ରହୁଥିଲେ।
But the father have stated that the second son was also residing in the same house.
Page number 33 କଥା କହୁଛନ୍ତି।
Yes, sir.
I have two sons, myself and both of my sons were living in separate mess. ଅଲଗା ଅଲଗା
ମାନେ ସେଇ
ରୋଷେଇ
compound ରେ ସେଇ compound.
ହଁ ରୋଷେଇ ଅଲଗା କରି ଖାଉଥିଲେ। Accused has gone mad over the
Even the mother-in-law, father-in-law also same compound, but other men. They were staying separately altogether. But in the same compound they were there. The kids are not examined, Your Lordship. Both the kids were not examined. And there is nowhere mentioned where they, that they were present or they were not present. What happened to them? There is no description about them. The accused apparels were seized, but whether it was a human blood, that is not human blood, but which grouping is not confirmed.
Which one?
The SFSL report, Your Lord.
କାହାର dress code?
Accused. One black, blue, black, white check lungi was seized. Human blood was found, but of which grouping, that is not mentioned.
No, ଆପଣଙ୍କୁ ସେ ବିଷୟରେ ପ୍ରଶ୍ନ ପଚରା ହେଇନି କଣ ଆପଣଙ୍କୁ? ଆପଣଙ୍କୁ ସେ ସି ରିପୋର୍ଟର ଯୋଉ ଫାଇଣ୍ଡିଂ ବିଷୟରେ ଆପଣଙ୍କୁ ପ୍ରଶ୍ନ ପଚରା ହେଇଥିବ ଯେ ଆପଣଙ୍କରଠୁ ଏମିତି ସିଜ୍ ହେଲା, ତାପରେ ସେଟା ଗଲା ସି ରିପୋର୍ଟ ପାଇଁ ଏବଂ ସି ରିପୋର୍ଟର ଏଇଆ ଫାଇଣ୍ଡିଂ ଆସିଲା, ଆପଣ କଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି?
Nothing there, Your Lordship.
चौदह नंबर क्वेश्चन होची wearing apparels were sent the chemical examination report 14 receive the C report that is not the situation.
Yeah, go ahead. It will be later. What is the welcome?
Three.
Wearing apparel, yes, page number 63. Wearing apparel of accused, that is a lungi of Bansidhar Sahu, ତାକୁ ମାର୍କ ହେଇଛି ସି ହିସାବରେ ହେଲା। ସି ରୁ ଆସିଲା କଣ ହ୍ୟୁମାନ ବ୍ଲଡ ଆସିଲା,
Grouping is not mentioned.
ଗ୍ରୁପ ଟା ହେଇପାରିଲାନି।
So whether that grouping is because
no,
16
no,
stab
he should have said.
ଆପଣଙ୍କର ଯୋଉ ଲୁଙ୍ଗିରୁ ଗୋଟେ ହ୍ୟୁମାନ ବ୍ଲଡ୍ ବାହାରୁଛି ସେଟା କେମିତି ଆସିଲା? ଆପଣ ଯଦି ଗ୍ରୁପ ନ ହଉ ଆପଣ have you taken a plea that
No, no such plea has been taken.
ତାଙ୍କ ନିଜ ରକ୍ତ ଲାଗିଥିଲା କି କଣ?
କହିଥାଏ ମାନେ ମୋ ନିଜ ରକ୍ତ ଏଟା ଲାଗିଥିଲା ଆଜ୍ଞା, ମୋର ଖଣ୍ଡିଆ ହେଇଯାଇଥିଲା, ମୋ ସେ ରକ୍ତଟା ଲାଗିଥିଲା, ସେଟା ମୋର। ଏଗୁଡାକ ଯୋଉଠି ଗ୍ରୁପ ନ ବାହାରେ ସେମିତି ପ୍ଲି ନେଇ ହବ, କିଛି ଅସୁବିଧା ନାହିଁ। ତେଣୁ ଆପଣ ଘର ଭିତରେ ଘଟଣା ହଉଛି, ଆପଣଙ୍କ ସ୍ତ୍ରୀ ପାଖରେ ଥିଲେ, ପାଟି ଶୁଣି ଅନ୍ୟମାନେ ଆସିଲେ, ଦେଖିଲେ ସ୍ତ୍ରୀ ମରିକିନି ପଡିଛି, 16ଟା ଇଞ୍ଜୁରୀ, ଷ୍ଟାଫ୍ ଠୁ ଆରମ୍ଭ କରି ସବୁ ପ୍ରକାର। ଆପଣ ସ୍ତ୍ରୀଙ୍କ ପାଖରେ ନାହାନ୍ତି, ଆଉ ଗୋଟେ ରୁମ୍ ଭିତରେ ରହିଛନ୍ତି।
ଏଟା 27 ଏଭିଡେନ୍ସ ଆକ୍ଟ ରହିଛି। ଷ୍ଟେଟମେଣ୍ଟ ତ ନାହିଁ।
କଣ ଗୋଟେ ରିକଭରି ହେଇଛି କି କଣ?
ନାଇଁ ସେ ଗୋଟେ ଦେଇ ଦେଇଛି ଉପରେ, it is 27 1862 27 ଧାରା ଅନୁଯାୟୀ।
ଆଚ୍ଛା,
but there is no statement, nothing of that sort. ସେଥିରେ ସେ
informant
ତଳେ
so-and-so,
କହିଦେଇଛି ତ
3 pieces of so-and-so, collected blood stain.
ମତେ ଡାକିବାରୁ ମୁଁ କବାଟ ଖୋଲି ଆତ୍ମସମର୍ପଣ କରି ମୋ ସ୍ତ୍ରୀର ମୃତ୍ୟୁ ପାଇଁ ମୁଁ ନିଜେ ଦାୟୀ ବୋଲି ପ୍ରକାଶ କଲି। ମୁଁ ମଧ୍ୟ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ମୋ ସ୍ତ୍ରୀକୁ ଆକ୍ରମଣ କରିଥିବା ରକ୍ତଭିଜା ଲୁହା ରଡ୍ଟିକୁ ବାହାର କରି ଦାଖଲ ଦେବାରୁ
ଆଇରନ୍ ରଡ୍ଟା ଆଇରନ୍ ରଡ୍ ଅଛି ଯାଇଛି as per seizure list exhibit 10 ଦେଖିବା exhibit 10 ଟା କଣ? exhibit ଟା list ଟା ଏଟା କେତେ ନମ୍ବର? 10 ନମ୍ବର exhibit ଟା ଅଛି ଏଟା 12 ଆଉ ଟିକେ ବ୍ୟାକ୍ କରିଦିଅ। এটা exhibit କେତେ?
Iron rod is exhibit P, your lordship.
ନାଇଁ ନାଇଁ seizure list ହଉଛି exhibit 10.
Exhibit.
So this is exhibit ଏଇଟା ତ circumstance of seizure ହେଲା ଉପରୋକ୍ତ ମକଦ୍ଦମା ସମୟରେ ଆସାମୀ ବଂଶୀଧର ସାହୁ ଘରୋଇ କଳିକୁ କେନ୍ଦ୍ର କରି ତାର ନିଜ ସ୍ତ୍ରୀ ଶୋଇଥିବା ଅବସ୍ଥାରେ ଗୋଟିଏ ଶାଣିତ ଲୁହା ରଡ୍ ଦ୍ୱାରା ଘୁଷି ମାରିବାରୁ ଏବଂ ସେଇ ଲୁହା ରଡ୍କୁ ରକ୍ତ ଦାଗ ଲାଗିଥିବା ଲୁଙ୍ଗିଟିକୁ ଉପରୋକ୍ତ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ଦାଖଲ କରିବାରେ ଜବତ କରାଗଲା ଓ ଜବତ ତାଲିକା ବିବରଣୀ ଆସାମୀ ଓ ସାକ୍ଷୀମାନଙ୍କୁ ପଢି ଶୁଣାଇ ଦେବାରେ ସମସ୍ତ ଶୁଣାଣି ଏଟା ହଉଛି ଦି ହାଉସ ଅଫ ଦି ଆକ୍ୟୁଜ୍ଡ ର ଜବତ ହେଲା। 26 ପ୍ରଡ୍ୟୁସ କରିଥିଲା ଶାଣିତ ଇଏ ଗୋଟେ ଚେକ୍ ଲୁଙ୍ଗି so that means the iron rod with which the assault was made that he has kept with himself. That was not there in that room. That was produced. That is how it was seized. କୋଉଠୁ ଆଣି ଦେଲା ଲେଖା ହେଇନି ନା? ଅନ୍ୟ କୌଣସି ଯୋଉ ଏମାନେ କହୁଛନ୍ତି ତାର ବାପା ଯୋଉ କହୁଛି PW2 has he stated that any weapon was lying there?
No, your lordship.
ଖାଲି କହୁଛି wall was there and before death I hard दिख रहा है nice.
I took a seized wood. It was wood.
Dead body was lying with stain of so-and-so. At that time, my son was in another room, so-and-so closing the door.
I took the seized wood in my zimmer.
Seized wood in my zimmer. ନାଇଁ ଗୋଟେ ଏଇଟା iron rod ସେଟା wood. This is an iron rod which is the and it is
ତା ନିଜ କୋଠା ଘର ପ୍ରବେଶ ରୁମ ରେ ତା ନିଜ ସ୍ତ୍ରୀ ମାଣିକୁ ଗୋଟେ ରଡ୍ ସାହାଯ୍ୟରେ ବକ୍ସି ରକ୍ତାକ୍ତରେ ମାରି ଦେଇଥିଲେ। ମଣିର ରକ୍ତ ହୋଇ ଧାର ଧାର ହୋଇ ବହିଥିବା ପାୟା ଯିବାରେ ବୋହି ଯାଇଥିବା ପାୟା ଯିବାର ସେହି ରକ୍ତର ନମୁନା ସଫେଦ ହେଲା। ଜବତ ତାଲିକା ମେଣ୍ଟା ହେଲା ତାର ଇଏ ବ୍ଲଡ ଷ୍ଟାଣ୍ଡ। ନା ଇଟ୍ ଇଜ ଦ୍ୟାଟ୍ ୱାନ୍ ଏକ୍ଜିବିଟ୍ 10।
ଏକ୍ଜିବିଟ୍ 10 ଟାରେ ଗୋଟେ ଶାଣିତ ଲୁହା ରଡ୍ ଥିଲା। ଶାଣିତ ଲୁହା ରଡ୍ ମାନେ ତାକୁ ସେଇ ଲୁହା ରଡ୍ ରେ ଷ୍ଟାବିଂ କରାଇଛି, ଯୋଉ ଲାସେରେଟେଡ wound ବି ସେଇଥିରେ ହେଇଛି। ତେଣୁ ଦି ପ୍ରକାର ଆସଲ୍ଟ ତା ଦେହରେ ହେଇଛି। ଗୋଟେ ଷ୍ଟାଫ୍ କରାଯାଉଛି ଯୋଉଥିପାଇଁ ଇଞ୍ଜୁରି ଆସୁଛି ଷ୍ଟାଫ୍ wound ଗୁଡାକ,
ଆଉ ଗୋଟେ କାଠର ବଲ୍ଲା।
ବାକି ତେଣୁ ସେଗୁଡାକ ସେଠି ନଥିଲା, ଯୋଉଠି ଡେଡ୍ ବଡି ପଡିଥିଲା ସେଠି ନଥିଲା। ମାନେ ସିଏ ତାକୁ ଆକ୍ୟୁଜ୍ଡ କୋଉଠି ଗୋଟେ ରଖିଥିଲା, ଯୋଉଟାକୁ PW ଏକ୍ଜିବିଟ୍ 10 ଦେଖଉଛି, ସେଟା ଆଣି accused produce kala, and accordingly the same was seized. And ସେଇ ଯୋଉ ଲୁଙ୍ଗି ଜବତ ହେଇଥିଲା, ସେଇ ଲୁଙ୍ଗିରେ ହ୍ୟୁମାନ ବ୍ଲଡ ଥିଲା। of course you are right that group ତାର କିଛି ଡିଟେକ୍ଟ ହେଲାନି। ଏବଂ ଡକ୍ଟର ହେଲା PW କେତେ? 13. Cause of death was due to shock as a result of injury to the vital organ like lungs, liver, and hemorrhage. This decision which you cited, it's just a general principle, that is nothing about this, that if you admit that you have committed an offense in your C13 statement, and there are other material on record against you, then whether in such a situation the trial court would be justified in convicting you or not. So tomorrow you ask one counsel to get prepared in this terminology. ସେଇ ମ୍ୟାଟରଟା ଆପଣ ରେଡି ହୁଅନ୍ତୁ, ଆପଣମାନଙ୍କ ଭିତରେ ବାଣ୍ଟି ଦିଅନ୍ତୁ, କିଏ ଆପଣ ଫେସ୍ କରିବେ। So if anyone present to argue any other jail criminal appeal which is there in the list, so ବୁଝୁ ଯୋଉମାନଙ୍କର ନାଁ ଅଛି ତାଙ୍କ might have taken the paper,